Hi guys, how are y'all doing? Happy, what day is it? Is it Wednesday? It's Wednesday. Happy Wednesday. We are waiting for court to start and for it to go into session. Of course, guess who's late? Not me. Not me. It's Judge Glanville. Court was supposed to start at 10 a.m. It is 10:22 here on the East Coast. I'm going to give you guys a quick synopsis of where we are. I am also pulling up the Supreme Court docket search engine so that way we can keep an eye out on the Supreme Court if they are going to give us an update on what's happening with the writ of mandamus that went up to them last Thursday, all of those things. So what are we talking about today? Let's start with an overview. We are on the Young Thug trial. Today is day 99. All right. So on day 99, we have a few things happening. Number one, Woody is not in the courtroom, right? So what you mean? He's not there, right? The jury is also not in the courtroom. We do not have court tomorrow or on Friday. So today is the last day of the week. We're gone for about 4 hours. So, counsel was supposed to be there at 9:30 to get started for 10 o'clock. And again, 10:23, and we haven't started yet. So that should tell you something. What the plan is for today is we're going to continue to go over um, some of his witness statements that he made during conversations he's had with the police. Why are we doing this? Well, Woody was difficult on the stand for the last 2 weeks. So the state early last week is almost forced to use his footage instead of using him because we know that he's not going to give you anything on the stand, right? So we know that that is happening. So, recap of last week, we saw Kayla Bumpus came on Lead's show, I think it was 2 days ago. So we had an opportunity to talk to her on Monday. The order to show cause meeting was supposed to happen yesterday. It did not. It got pushed to July 3rd. And again, guys, I know it sounds like I'm in a forest, but I'm in Boston this week temporarily, just doing some stuff for school, things of the like. But I'll be back in Atlanta later this week. So I apologize for the birds. We live very close to the ocean, so hopefully it's relaxing. Hopefully it sounds relaxing. But throughout the trial, I will be on mute. Anywho, so order to show cause was rescheduled to July 3rd. Apparently, I'm not sure if that's going to be televised, but we know that that has been rescheduled. In other news, the other thing that's coming out is the transcript. We have all been waiting to see the transcript. The defense attorneys have been waiting to see the transcript. Judge Glanville is making the transcript available to the defense counsel. That's going to be on July 1st. So that this upcoming Monday, they will be able to examine the transcript. But here's the thing, they have to do it in Judge Glanville's chambers. Okay, like they're not even going to have an opportunity to print it out, any of that stuff. They're going to have to look at it in Judge Glanville's chambers. So that is interesting. Brian Steele wanted Young Thug present for the transcript as well. He wants his client to be able to take a look at it. And guess what? That's not going to happen. The judge, he denied that request. So we are kind of in a position where we're going to wait to hear from the defense attorneys, and we're going to see how they respond to what they found in the transcript the following day, right? So that's going to be interesting. Now, I am just going to bring up the feed so you guys can follow along with me. As you see, they are not in the courtroom yet. But what I do want to show you is this. So every morning, I like to go to the Supreme Court of Georgia, and I go to case information and docket search, and I like to check out where we are with this case. And this is public information. You all have access to this. So we have the writ of mandamus that went up to them, Diamante Kendrick versus Ural Glanville, Chief Judge, right? If you look at the case status, that tells you where it is. It's been docketed. So we haven't had any updates since June 20th. So just keep that in mind. Like I'm checking it every day. Also keeping an eye out on Twitter to see if we have any updates, because sometimes they slide in throughout the day. We have the attorney information and then we have judgments. And as you guys can see, nothing has happened just yet. So we're waiting on that. But while we do that, I'm going to go ahead and see who we have in the building. Say hello to a few of you guys. And then also give a huge shout out to the sponsor of today's stream, Aura. If you're looking to protect cybersecurity, if you're looking for VPN, if you're looking to protect your credit, all of that stuff, check out Aura. I have a discount code with them that's in the description box below. 14-day free trial. Okay, try it for 14 days, see if you like it. But my favorite thing that Aura does is they stop the robocalls. I can't tell you how much I cannot stand robocalls. You know how you see numbers that you don't recognize or numbers from other countries. Aura stops that. Right? It's like 19. It's like 14.99 a month. So it's not expensive. Check it out. And again, guys, if y'all use my promo code, you get it free for 2 weeks. So give it a shot. And if you don't like it, cancel. It's free. So check it out. Let me know what you guys think. All right, let's see who we have. Shout out to Chi Chi. Chi Chi, that's cute. Good morning. It's good to see you. Shout out to Lovey, who's in here. Chi Chi, that's cute, says good morning. Granny of Five is in here. Roxanne, good morning. Good to see you. Roxanne says, I didn't think that they were going to get Woody on the stand today. Yep, so I kind of mentioned that. You were hoping to hear from the Supreme Court. So yeah, guys, I have that docket up. I'm going to keep checking it to make sure that we're good to go. And, throughout the day, throughout the week. And if we get anything back, then you guys will be the first to know. Shout out to Carol, one of my faves. She says, good morning, AV, praying for your success with this class and your upcoming test. Yeah, I'm up in Boston for bar exam boot camp this summer. So I know it sounds so cheesy, but basically what it is every week we're going through different bodies of law in preparation for the bar exam. And for, like you guys probably don't know much about the bar exam. It's a 200 questions, right? Over 7 bodies of law. So everything we've learned in law school: civil procedure, criminal law, constitutional law, contracts, business law. I know I'm forgetting others right now off the top of my head, but every week we just kind of practice with these questions. But the other thing that comes up is essays as well. And you have like a certain amount of time to do your essay because you have to memorize what the law is. So I'm cramming a lot up here these days, but I'm giving myself plenty of time to prepare for the bar exam. I'm not just going to give myself 3 months and cram it. I'm going to give it a few months and get ready for that. So that's what I'm up here for. Shout out to Kim. Good to see you, Kim. And shout out to Robin. Robin is here as well, who says, who in their right mind would rent a car in their name knowing that it would be used in a deletion? Oh my God. Is that what happened? Is that what's been happening? That's so interesting. Let me check in on the feed to see where we are. Yeah, nothing yet. A little bit of movement, but nothing yet. I'm going to keep checking the feed here and there just to make sure we're in good shape. And let me make it big over here so that way we don't see their chat. Our chat is so much better. But let's see who else we have. I'll keep it up so that way as soon as we see some movement, we can jump in. Shout out to Brian. Good to see you, Brian. Hi, Trump girl. RTP. Yeah, good to see you, RTP. Oh, and also you mentioned the lead. We're not going to stream on his side today. So I'm going to be covering it here on my side. So if anybody was looking for lead, he's taking the day off. Much deserved rest needed, right? We all need days off from time to time. So there will be times where we'll be solo streaming, from time to time. But it's nice to take some time off because we want to make sure that we get you guys the content and keep you up to speed on the trial. Shout out to Tay Biz. He said, AV got people in the lobby. Let's go. Right? I was looking at that. There's 1,000 of you guys in here. Do me a favor. Hit the like button. I'm not going to lock you out. People got mad at me yesterday because they're like, why are you always threatening us with likes? I'm like, listen, I'm just trying to let you know, like, you'll get locked out over here, right? On my side, I don't necessarily do that yet. I'm a little bit too small as a creator to start, but I want you guys to be able to participate in the chat and have a good time. So we'll definitely do that. Shout out to Mike and 10, who's shouting out my Instagram. If you guys are not following me on Instagram, you're gonna want to do that. Usually me and my editor work on weekly recaps and we do it there. All right, we had some movement. It looks like they may be entering the courtroom. I don't see any people yet, but I did see some movement. So we'll keep an eye out on that. Again, my Instagram handle is right there. It's AV7official. If you're looking for me on Twitter, it's AV to the 7th power. Same here. Hey, EC. Good to see you, EC. Dream is in here as well. Eric is here. He says more likes and people waiting, right? Isn't that a good start? It's such a good start. Yeah, I cannot believe that they are constantly late. Like, it's just like, don't, and you're having the attorneys start like show up at 9:30. Hopefully there's not another ex parte meeting happening. Too funny, but let's see who we have. You guys are becoming members. Look at that. Shout out to Mama, who became a YouTube member. Thank you so much, Mama. Welcome to my community. It's going to come with its benefits. And, we have like a nice little community here, and you're going to want to get your membership, because at some point when your girl starts growing, I will start to make some of our chats members only. So keep that in mind. Shout out to Nick Starro, Trial Watch. Look at that. Brother to the channel. He drops me 200 Swedish bucks. He says, with GSC decision, yep, so the Georgia Supreme Court decision on former Judge Peterson, finding her conduct regarding the criminal contempt hearing she performed as blatant disregard of due process. Can that be an indicator of how they will regard Glanville? Nick, this is such a great question. And guys, check out Nick. He is a content creator. He's been trial streaming this trial from the very beginning. We're on day 99, and he's watching from Sweden. Great legal professional, one of my favorite folks. And, his channel has been growing covering this trial. But he has a good question. Two things to break his question down. Number one, you guys saw the judge, the body cam footage that I had reviewed over the weekend, that a lot of people were upset about. That is Judge Christina Peterson. She was in Atlanta at a nightclub. I think it was a lounge last Wednesday night going into Thursday morning. She was with a group of friends. There was an altercation between another woman and a man, where I've seen the footage. It was sent to me and Lead earlier this week. There was a man that indeed punched a woman in the face. It was pretty violent, right? The judge intervened. She chose to intervene and break the fight up. However, there were security bouncers, and there was a police officer in the process of breaking the fight up. Okay. In that fight, the judge punched a police officer in the head, right? So he restrained her. He arrested her. While she was in the process of being arrested, he would constantly ask her for her name. I will say this, in the process of the arrest, her friends took her purse. Her friends did mention her name. Her friends mentioned that she was a judge. However, Christina had some pretty unruly behavior. That was her decision. She chose to act the way that she acted after the fact. I do think that she could have cooperated. That's my opinion. And it would have saved a lot of time, because the body cam footage that we saw ran from about 2 p.m. to 5 a.m. Does it make what happened right? No, on either side, right? It shouldn't have gone that far, is my opinion. I don't think it should have gone that far at all. Now, Christina has a lot of background with some things that have happened while she was a presiding judge. There was some, I'm not going to say malpractice. I want to be very careful with my words here. But there were some issues that she had while she was a judge. And the Supreme Court of Georgia has decided, and this came out yesterday, that they were going to kind of revoke her status as a judge. And she has acknowledged that. I've seen her Instagram. She's just like, I'm a former judge. I'm no longer a judge. She is open to talking about her story. Some of you guys want me to talk to her. Given the type of content that was, I'll be honest with you guys, I don't like to touch it anymore. I really don't. When there are things that are like gender specific, I understand that I'm a female kind of talking about this stuff, but people look to me to be a leader in this space. And, my content is really focused on legal matters, and that's what I want to focus on. I really don't want to get caught up in any gender wars, right? So let me actually pull this down for a second, and I'm just going to make that abundantly clear. Like, my content is legal content. I'm not here to get involved in anybody's gender war, right? So if that is expected, I'm making that statement as a creator right now. I'm very passionate about teaching people about how the law works, because I'm coming from a place where I've learned about it. That's the type of content that I like to make. And like I mentioned, I was really disappointed. There were a ton of people that mass flagged my channel over the weekend. That was really surprising. And again, it is what it is. No harm, no foul. But moving forward, this is a legal channel, and that's what I'm going to focus on. So, anyway, Nick, thank you so much for the super chat. I really appreciate that. But to answer your question, can that be an indicator on how they will regard Glanville? Well, there's a few things. They said blatant disregard of due process. The other thing that they mentioned was ex parte meetings came up in that decision. What I'll do is pull that decision, guys, and maybe do a video for you later in the week just to break the decision down to see what they were thinking. Again, you have judicial conduct. It's such a big thing. So, well, neither here nor there. It's one of those things where there are some things where the Supreme Court is looking at how they are making decisions. The other thing I'll mention too, guys, is they made the decision to have her step down very fast, right? So as we are looking at, something like this, where we shift gears to Glanville, I think we can get a decision a little bit sooner than we think, because it's really focused on his, behavior, right? His conduct, the whole ex parte meeting, even the transcript. He is now making it available. How interesting that, the writ of mandamus comes out on Thursday, and then Monday we get, now he's making the transcript available. So I wonder if he takes the threat of this going to the Supreme Court seriously. I mean, he should, and I would imagine that he will. Right. So thank you again, Nick. And guys, if any of the mods are hanging around, if you could drop the link to Nick's channel, that would be fantastic. And again, guys, sorry about the birds. They are just so loud over here. Shout out to Real Talk with Retta, who has been a member for 13 months. Retta, thank you so much. And look, we have some movement. We have a little bit of camera movement.
All right.
Woo.
Court county is now in session. I'm Chief Judge Ural Glanville presiding. Court come to order.
All right, good morning, ladies and gentlemen. Please be seated.
39 minutes late.
All right, we're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. All right, Mr. Stilwell and Mr. Botts and Mr. Sharp, good morning. All right, Mr. Williams, Mr. Steele, and Mr. Adams, good morning.
No, sir.
All right. Good morning, Ms. Halterwinger. Where's Mr. Monsbach? I saw him walking around here a second ago. All right. Okay, he's here. All right. Mr. Kendrick and Mr. Weinstein, good morning.
Good morning, Your Honor.
All right, Mr. Huey and Mr. Matthews, Senior, good morning.
Good morning.
All right, Mr. Nichols and who? Where is his other two counsels, Ms. Westmoreland and Mr. Garner?
Oh, we got missing lawyers. Woo.
What's
Oh
the
my
name?
gosh. These mics.
Okay, all right. Mr. Nichols, do you have any objection to Mr. Botts for filling in for today in this role? Do you? Okay, have they discussed this with you? They being Mr. Harvey, Mr. Garner, or Ms. Westmoreland? Okay, and you're okay with Mr. Botts representing you today for the purposes of this particular hearing? All right. All right. Mr. Ryan and Misty Williams. Good morning, madam. All right. Mr. Smith, Mr. Uhowski, Ms. Knight, Ms. Hilton, Mr. Atkins, and Mr. Brown. Good morning. Good morning. All right.
Oh my gosh, they're mics.
Is Mr. Yusuf over there in the corner? Okay, all right.
It's blue. It's blue, Brian. Look. Oh my goodness, I can't. Why do they do this? That is a good question, DJ Vibe. Miss Love has been on another legal matter throughout the week. Yes, there was a hearing. Ashley Merchant is suing the Fannie Willis's office. I'll give you guys an update on that later.
Councils, I believe that when we left off last night, Mr. Adams and Ms. Hilton, you have advised me that you have 6 remaining areas from the June the 26th
Yes, sir.
interview.
We did.
Okay.
That is what we indicated yesterday.
And so
do we changes?
Okay, all right. Can we pick up, Mr. Adams, if you'll just tell the court which one from I'm using your proposed redaction, which is already a court exhibit, and has been forwarded to Ms. Weaver.
Yes, sir.
Tell me which one you start off with, and we'll
Do the covered on
like
which
we did yesterday.
Okay, with the court's permission, what I'll do is I can outline for you the 2 that we have since yesterday agreed on.
Okay, and go ahead and give me those.
The first one is going to be, and this is an agreement with some change, where it says page 491, line 14 to page 492, line 5. So what we have agreed to is that what should be redacted is page 491, starting at line 16 instead of 14. So page 491, line 16, all the way to page 492, line 5.
Okay. And Ms. Hilton, what are the corresponding video audio time references?
And there's also connection extensions, so for line 16, it'll start halfway in that sentence, and so the beginning time.
Oh my God.
53702.
53702 2.
And then we'll actually extend to line 14
Right.
on page 492, and that will go to 53753.
Mr. Adams, are you in concurrence with those
Yes,
changes?
I agree with that.
All right, anybody else have any further discussion or argument about those particular time periods? All right, hearing none, sir, go on to the next one you've reached concurrence with.
Yes, sir. The next one, if we drop down to page 500, line 15, page 500, line 23. In my notes, that is an excerpt that references Mr. Copeland referencing text messages with D and or Shannon in regards to killing or doing harm to him. And we agree that those lines should be redacted.
All right, is the statement in concurrence?
Yes, Your Honor.
Can you give me the corresponding audio video marks,
Sure.
please?
It's gonna be 54545.
54545.
Yes, to 54601.
Okay. All right, any further discussion or on that particular period? Okay, all right. All right, so that would mean you have 4 left.
Yes, sir.
Okay.
And
Which one you want to start off with?
All right, so the first one is going to be page 488, line 1 to page 491, line 10. And my description of that is as follows. In my read of it, Mr. Copeland is talking about Donovan Thomas or Nutt's murder based on what he heard, what he thinks, and his opinion on what happened. I'm perfectly content to let the court either read through the transcript, it's a number of pages, or listen to, look at and listen to Mr. Copeland's audio visual interview on it. But my objection to that is that it contains items of hearsay. It infringes upon our ability to confront the witnesses who he says he's hearing that information from. It involves some speculation. And it also lacks foundation. What I mean by that is Mr. Copeland has been testifying on direct. We've not yet gotten to the point where he's going into any detail about what he knows, what he purportedly knows about Donovan Thomas's murder. So he hasn't yet testified that this is what I know happened, or this is what I heard happen, or this is what I saw or think happened. This person was involved, this person was in a car, and that's my example, but we haven't gotten into those details as of yet. In the excerpts that I've indicated, he does go into that detail, and he is talking about hearing information from Demikian, from other individuals, and he gives great detail about this person was driving. So, for example, if you look at page 488, Your Honor, down towards the bottom, line 22, the detective asked him, for example, so it was Yak driving, Shannon with the AK, Nard with the pistol, and Doo-Wop with a pistol. And going over onto the next page.
Thanks, Gerald.
Mr. Copeland says, nah, I don't think Doo-Wop had no pistol. So he's going into, and I'm sorry, if you go down a little bit more to line 6, where he says, yeah, I just know Yak. They said Yak was the driver. So obviously when he says they said, right, he's referencing hearsay, but he's going into great detail. My problem is that they haven't asked him any of that yet. And
Thanks, Tanya.
if their reason for wanting this particular portion of the audiovisual interview played is that it is impeachment by contradiction, well, he hasn't said anything yet about these details.
Oh, my ears.
They haven't laid the foundation. This is kind of something you addressed on yesterday,
Yes.
Your Honor. They haven't laid the foundation by asking him any questions so that they can now go into it and just carte blanche play what he says. Because what happens then, if you allow this, is they're playing the video, and essentially the testimony is coming out based on this audiovisual interview, as opposed to him testifying about it and either admitting or denying that this is what he knows.
Shout out to South Africa.
So my objection would be foundation first and foremost, and then the other things that I've indicated: hearsay, inability to confront the witnesses that he says he gets this information from, who would be, I think they're going to say these are co-conspirator statements, right?
Okay, guys, but I see a few of you guys asking questions, so I'm going to explain what's happening. So the person that's speaking right now is Young Thug's lawyer. He's Brian Steele's co-counsel, Mr. Adams. Now, today we're going to review the last 6 pieces of evidence for the week. There's 6 of them that they're going to look at. And of course, they're all pieces from Lil Woody's interrogation videos. Now, the part that they're talking about right now is when Lil Woody was talking about his opinion of Nuts' murder. Okay. And he is objecting on 4 grounds. He's saying that it's Lil Woody's opinion on what happened, right? So it is hearsay because he's referencing something that someone else told him. So we know what hearsay is. It's an out-of-court statement made for the truth of the matter asserted, right? So we know that it's something that someone said to somebody else. So someone said this to Lil Woody, right? Now he's also saying, number 1, it's hearsay. Number 2, I don't have a right to confront Lil Woody on this because he's the witness. I should be able to cross-examine him, right? He's also saying that it's speculation from Lil Woody's part, right? Because how do we know that these things are true? And then lastly, he's saying that there's a lack of foundation. So again, Ms. Hilton is trying to bring this in because she needs it, right? She wants the part where he's talking about Nuts' murder. And I believe there was a reference to Yak as well, right? So Young Thug's team wants to keep this out because of those 4 reasons. That's what Mr. Adams is arguing about, or at least that's his stance on this right now. We'll see how Hilton responds, but we'll let him finish up. I just wanted to explain that to you guys really quickly.
Demikian Garlington, for example, he's a co-defendant. We can't call him in cross-examination.
Oof.
And then finally, that some of his testimony, some of his statements here is speculation. So that's my objection.
Okay. All right, Ms. Hilton.
Yes, Your Honor. So first, I'm going to start with the foundational argument that we have not asked Mr. Copeland about the night Donovan Thomas was killed. We did, in fact, ask Mr. Copeland about that. Your Honor, when I had
Ask him about the guns or who was in the car?
We did. So, Your Honor, on June 13th, we actually asked this series of questions. And this is all in relation to the night that Nut was killed. My question to him was, after you left Mechanicsville, did you go anywhere after leaving Mechanicsville from what you remember? Yeah. Do you remember where you went? Pick Little D up. Okay. And which Little D are we talking about? the one that always be with me. Okay, is that the little D you referenced as your son? Yeah. Do you remember where you picked little D up? Where did you pick him up at? McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to the McDonald's on Cleveland Avenue, was there anyone else with little D? Just him and Shannon. Anybody else? Just him and Shannon. When you picked up little D, what did Shannon do? What do you mean? You said you picked little D up. Did you also pick up Shannon? I said I picked them both up. When you picked up both of them, where did you all go? I blanked out after that. You blanked out after that. Okay, why did you blank out? Because they were saying that I got the phone call. Do you remember who called you? So I asked him what occurred in the car. What's happening? He says he blanked out. So at this point, if he blanked out, he does not remember anything that happened in the car, which would be the conversations that he had with little D. And well, what he's now saying Shannon, but previously he told the detectives that Nard was in the car with him. And I believe that I asked him further on, and we don't have this part of the transcript, did Nard ever get in the car with you? And he says, no. So, Your Honor, we have confronted him as it relates to what occurred. Let me go further. Excuse me. I'm going to go down to the transcript. Now, before Monton called you, did you, Shannon, Little D have any conversation about Nut being killed? No, was his response. That's a complete contradiction to, that's impeachment by inconsistent statement that he said, no, they did not have any conversation about Nut being killed. So as far as foundation is concerned, we have met the burden of the fact that this statement now comes in, one, impeachment by contradiction, but two, as a prior inconsistent statement. As far as hearsay, Your Honor, you've already ruled that what Demekian told Copeland in the car comes in as co-conspirator hearsay. The court has already made a ruling on that. And when you look at page 488, excuse me, starting at line 1, Detective Thorpe's question is, okay, so let's go back to Nut. Make sure I got everything right. Demekian pretty much told you it was him, Shannon, Nard, Bentley. Copeland corrects him. Nah, it was Demekian and Thug, D and Thug and the girl. Supposed to went to Bentley's house. This is based upon what Demekian told him. He says, you feel me? And when they got finished doing that, they supposed to pull up on him at the house. But I think the girl Bushi, you know what I mean? That's the girl who's supposed to, she know what's going on. You know what I mean? This is the girl Shannon turned against me. You remember they came and shot at us while I was in the car? This is the girl who I thought told them that I was at the hotel with them. He's now referencing what he told the detectives about, I believe in the January 28th interview. He's now referencing what he told the detectives in January 28th about Bushi potentially setting up him getting shot at on the highway. And then detective says, right? Then Thorpe says, So it was Yak driving, Shannon with the AK, Nard with a pistol, and Doo-Wop with a pistol? He says, nah, I don't think Doo-Wop had no pistol. Okay, right. But you just know what seats, how everybody was sitting in the car. All you know is Yak was driving. Yeah, I just know Yak. They said Yak was the driver. Again, talking about with Demekian. Because he said, and that's based on what Demekian told you? Yeah. Little D? Okay. Did they say that anybody else or just in y'all circle? He says, nah. I told people, you did? Because I just wanted somebody to believe that I ain't do it. Yeah, I told Big Boo who did it. Like, shit, boy, goddamn, they did. You know what I mean? I never know what was going to happen. I was just like, don't say nothing. Him telling what he told Big Boo. Then continue on. But I think if y'all, and it's indiscernible, but I think he's saying that Shannon told New Baby. I know Shannon too much. I think Shannon told New Baby himself. You feel me? And New Baby's his girl? Yeah, New Baby. So you know what I mean? Because the story came out, though. 2 people said it. What? That Shannon and them killed him. You feel me? Like Bentley's girlfriend is Nut's sister. Yes, his baby mom is Nut's sister. And you know what? You know what she told him? What? how could you be around him and he's supposed to kill my brother? And Bentley said, if you feel like he killed your brother, just let me know. One call and it's on. That's why me and Bentley fell out. You know what I mean? So again, he's offering that comment to say, this is why him and Bentley fell out. Then he says, you know what I mean? You don't let nobody tell you no shit like that. Nigga, you know I ain't had nothing to do with that nigga getting killed. Detective Thorpe says, I'm gonna make a phone call. Detective Thorpe actually leaves the room. And then Kenneth Copeland continues to say, you feel me? So when I tell Bentley that, bro, you sitting around here telling this girl, if she want me dead, just say it. And they going, you know what I mean? So I believe you when you're saying it. They would have killed me to get it off of him. And then he goes and say, I told Thug that. And Thug was like, nah, he's just trying to throw her off. You know what I mean? Hell no, I ain't going for it. So, Your Honor, the hearsay portion that defense counsel is claiming is hearsay is not. It is the co-conspirator statement of Demekion Garlington when he told
bad argument.
Mr. Copeland what happened the night of the murder. And we have laid the foundation to introduce that because we've asked Mr. Copeland here in court, what did you all talk, or did you all talk about the murder when the three of you got in the car? And he says no. So this is a complete contradiction to that first assertion. So foundationally, it gets to come in as impeachment by a prior inconsistent statement. It is not hearsay because the court has already ruled that what Demekion told Mr. Copeland is a co-conspirator statement. And that really ends on page 489.
She is right about foundation. I don't know about the hearsay part.
Line 14, anything that Demekion told Copeland is from page 488 when Detective Thorpe is trying to clarify what Copeland said Demekion told him. And that goes all the way to page 489, line 12. And Thorpe confirms multiple times, this is based upon what Demekion told you. And he says, yeah. So again, this is the co-conspirator hearsay. After line 14, that's when he begins.
What page now?
On page 489, that goes into who Copeland told about it. So Copeland is now saying, I told Big Boo about it. And he told Big Boo not to say anything.
Is that going from 480, line 14, page 489 to the end, 491 at line 10?
No, that's only from page 489, line 14 through page 489, line 24.
Okay.
Then when you flip onto page 490, this is Copeland telling the detectives that he thinks Shannon told New Baby. And he's saying that more people knew about the murder, so his thought is that maybe Shannon told New Baby. Now, that is speculation. The state has no objection to taking out that portion of it.
What part?
So that would be page 490, line 1 through 8.
All right.
And I would have to get the timestamps for
Mr.
that.
Short, you.
Mr. Adams is going to argue irony of this, but
It's your client, so that's what I wanted to ask you. Okay.
to the overall reaction,
We,
specifically, I'm also arguing that 491 through page
491 to what, sir?
490, page 490 lines 1 through 8, as Ms. Hilton just said. That.
Okay. All right. Yeah. Well, I think that she's agreed to redact that as it pertains to your client.
Yes, sir.
Among any other objections that are being lodged, to include the general objection about not playing the videos at all. So
And I'll actually extend that to line 12, Your Honor.
so 1 to 12
Yes.
on page 490.
Yes.
All right, that can be omitted out. Anybody wish to have any discussion in regards to that particular omission of just 490 to 1 lines 1 through 12? All right, hearing none, those will be edited out. Okay, what else do you have?
Then he picks up explaining that
He being who?
Mr. Copeland picks up stating that at line 15,
Of what page?
490, that his baby mama is Nut's sister, referring to OG Bentley. And he goes in to say, you know what she told him? What? How could you be around him? And he's supposed to kill my brother. And
That's
Bentley
hearsay.
makes his comment, like, if you feel like he kills your brother, just let me know. One call and it's on. That's why.
Okay, let me just back up a second if I can interrupt you. Sorry. When he being Mr. Copeland is talking
Oh,
about
look
his
who it
baby's
is. It's
mama,
Miss Love.
He's talking about
that the mother
Nuts.
of who's he
All up in the
referencing?
camera.
He's referencing Mr. Donovan Thompson's sister, who is also the mother of one of Calvin Treadwell's children.
We heard testimony about that.
Yes.
Okay. All right.
And
Okay.
it's not hearsay because he's given his reason why him and Bentley fell out. So he's saying, he being Copeland, excuse me, is saying that
Yes,
the sister in a conversation with her child's father is saying, how could you be around him? Meaning, how could you be around Copeland if Copeland's supposed to kill my brother? And then Bentley's response to that was, if you feel like he killed your brother, just let me know. One call and it's on. Copeland is saying that conversation is the reason why he and Bentley are no longer friends. And that furthermore, he says to Bentley, why would you let her say that to you if you know that's not true? You know, I have had nothing to do with him getting killed, him being Donovan getting killed. And he also tells Bentley, bruh, you sitting around here telling this girl if she wants me dead, just say it. So, you know, I believe when y'all are saying they would have killed me to get it off of him. And then he being Copeland, tells Thug about the conversation of Bentley with his girlfriend. And Thug's response to that was, he's just trying to throw her off. Like, don't worry about that statement. And so we believe that all of that comes in as relevant, that is non-hearsay in this case. So
it's total hearsay.
the entirety of the section, exclusive of the part that we agree to redact, should should be played, excuse me.
All right. Can you give me the time references, if you wouldn't mind?
No, Tim, they're not in there today.
So for the first portion, Your Honor, which is
Page 488 to 489, line 12.
yes, that will be approximately 5:33:55
to
to 5:35, approximately 15.
Okay. And
This-
then the next portion, I believe, is page 489, line 14 to 489, line 24.
Yes, Your Honor, and that would be, I would say approximately 5:35:20
5:35:20
to approximately 5:35:32.
Okay. All right. And then
All right, guys, shout out to Atrium Lady. I'm taking it out of legalese for you. Here's the thing. So remember, I told you that Adams had 4 objections to this. He said 1 was hearsay. He has 2 as being able to confront Woody, the witness, 3 speculation, and 4 foundation. Now he lost on foundation. I will give Hilton that one because she did ask little Woody while he was on the stand a week and a half, 2 weeks ago. She asked him this question and he answered it. But he answered it in complete contradiction to what he said in that room. So foundation is out. Adams loses that one. Now, speculation, confrontation, and hearsay, I don't see her winning that just yet. She's trying to explain it to the judge. She keeps saying that it's not hearsay, but it is. He is, because you have to remember, his client is Young Thug, right? What he's trying to get out is the conversation between Young Thug and Lil Woody, where they was talking about somebody's murder, right? Talking about someone named Bentley, and Young Thug mentioned something along the lines of like, "Oh, don't worry about that." Trying to throw him off of the scent or something like that. It was about somebody's brother and the things of the like. So what Adams is trying to do is to get that statement taken out of the transcript. He does not think that statement should go in front of the jury because it's also hearsay. Like, Lil Woody heard something from somebody else and he's talking to Young Thug about it. And although it's in the footage, they're trying to get that part taken out. So I hope that helps. Hilton still has three, like she's trying to attack the three other objections. Adams lost the foundation one, but let's see if she is successful on hearsay, confrontation, and speculation. I don't think she's going to win the hearsay one, but let's see what she can do here. And of course, the judge has been giving her a few points with these, like taking some things out or keeping them in. But yesterday he kind of favored the defense slightly. So we'll see what he does today.
Oh, the omitted part that you wished you've agreed to take out in regards to Mr. Stillwell on page 490, lines 1 through 12. What is that?
I think, John, that's going to be approximately 535, probably 40 to 536.13.
Okay. All right, and then 490, line 15, I think through the end. What does that go to?
So from 490, line 15 through, and this actually bleeds into what we just discussed that we agreed to.
491, line 10 or something like that. I think that was the end of the section that you were talking about.
Yeah, so that bleeds into, so we would start around 536.21, and that would be 490, 536.15, which would be 490, line 15, and that will go all the way through page 491, line 16, which would be 537.00.
Okay. All right. Mr. Adams, anything else before I rule?
Yeah, I want to address the foundation argument again, because Madam Prosecutor quoted from her direct examination of Mr. Copeland in asserting that they had laid the proper foundation to impeach him with the specifics of this statement. The last question that I heard after Mr. Copeland says, I blanked out, is where he's asked about whether in a phone call that he receives or in the car, and that's very specific, was there any discussion about Nutt's murder, right?
That was on the stand.
Right, when he was on
the stand earlier.
Right.
Okay.
That's as far as the questioning goes in
No,
terms
Matt.
of any
It got
details.
rescheduled.
Right? Now, if you look at the transcript and if you listen to his statement, there's no indication as to the information that he's relaying that he got from Demikian or anyone else when he got that information. So I would agree, all right, I'm going to be as objective as I can here and say that if the state had gone further in their questioning, right, and say, okay, well, what about later on? Did you all meet anywhere? Did you all talk about this at any point after that? But they were very specific, and they ended the last question about what he knew about Nutt's murder was in a phone call or in the car. And so it is clear in my reading from the transcript that Mr. Copeland is referencing other conversations that take place at other times, and they can't simply say that, well,
That's a good
this is
argument.
impeachment by contradiction based on, the answer to those two questions. And so I think that there's additional foundation that needs to be laid before they can simply carte blanche just kind of throw this entire statement in there. Additionally, that's foundation argument. In regards to page 490, starting at line 15.
Yes, his baby's mama is not sister.
There you go. The entire conversation is what Nut's sister, who is not a co-defendant, what her conversation is with Bentley, who is not a co-defendant. And to say that the reason we want that here, that is clearly hearsay. You know, Copeland's relaying what he knows about a conversation between two other people, not even him. He's not party to that conversation. Right? He hears about that conversation. So he's relaying what he heard there and the statements that are made by Nut's sister and Bentley. And so it's clear that that's hearsay.
Here, can I stop you? I have just a question about that. Would that be that section where Mr. Copeland's talking about his baby's mom is Nut's sister and that, would that go to effect on listener about what he did or what he said afterwards?
I don't think so.
Why not? I'm asking because I follow your argument about, and I'm looking at the transcript as well, and about what is being said, but why wouldn't that fall under that issue effect on listener where he's clearly talking about what the baby's mama, Nut's sister, and what she told him, and then
and Bentley. Because here's why. Because the state points to one line on line 21 where it says that's why me and Bentley fell out. Well, there's no relevance to that. That doesn't have anything to do with his recitation of the information he has about Nut's murder, right? Because those are the questions that are being asked, and he's relaying what he knows about Nut's murder. And so for him to inject in there this conversation between Nut's sister and Bentley, and what they said, and that's why he and Bentley fell out, because Bentley makes a statement about that conversation that doesn't really have anything to do with the information that's being relayed.
Okay, let me freeze. I'm gonna let you finish your argument, Mr. Adams. I want to ask the state's response as to what's the state's response as to that, basically 490 lines 15 through 22.
Yes, Your Honor.
What, because it is a hearsay statement from Copeland's relaying what Nut's sister and Bentley told him.
So let's put it in further context. Bentley, the state alleges, is a co-conspirator in the YSL gang conspiracy.
He's an unindicted co-conspirator.
He's an unindicted co-conspirator. And Mr. Copeland has just reiterated Bentley's role in the murder of Donovan Thomas, that he is the place where both the car gets disposed of as well as the guns get disposed of. And so what he is saying to the police is, Bentley and I have now fallen out. Bentley and I are no longer friends, given what he is telling this woman about wanting to kill me when he knows I had nothing to do with this murder. And so we're not offering it for the truth of the matter asserted as to whether or not Bentley actually said, if you feel like he killed your brother, just let me know, one call that it's on. It is the effect that had on Mr. Copeland, and in turn, what he does with the information. He then confronts Bentley about it, but then he also asks Thug about it as well. And that is why, to put what he did with Thug is a context.
This might be the last one, D.
The jury needs to understand what preceded that. Not that we're offering it for the truth of the matter asserted, but what preceded.
Charles, we don't have a decision from the Supreme Court yet. I checked this morning.
but what preceded why he was upset that Mr. Bentley would even mention that to his Mr. Donovan Thompson's sister, and the fact that it upset him so much that he even mentioned it to Thug. Like, why would this co-conspirator say that he knows I have nothing to do with this murder? Why would he tell her that he would have me killed and he knows I have nothing to do with this murder? And so again, it's not being offered for the truth of the matter asserted, but it's being offered for the effect on the listener, being Mr. Copeland and what he did with that information. And I can't address the foundation issue again, Your Honor, regarding us getting this into evidence. So first things first, Mr. Copeland told the detectives that Little D told him about the murder once he got into the car. He began speaking about the murder once he got into the car. And then in his initial statement, he says that once Nard got into the car, they stopped talking. And then when Nard got out of the car, when they get to Sky House, they continued the conversation. So when I asked him in direct, was both, did you, Shannon and Lil D, have any conversation about Nut being killed? And this is why they're in the car. He said, no. He said, I did not, which is inconsistent and in contradiction to what he told police. What he told police is, in the car, he told me about the murder. He told me about what happened. And so it is, the foundation has been laid for this to be entered.
Mr. Adams, you can complete your argument. I thank you for allowing me to hijack you at that point.
No, I think I've done. I'm recounting what I recall from his direct testimony. I still don't think that there's been specific enough questions asked of him on direct such that what would be played in this would be impeachment by contradiction. And also, I've got to say, I reject the thought, going back a little bit to the other argument, that, Bentley's an unindicted, everyone's an unindicted co-conspirator. They hear the state tell it. If their name is referenced, they have some conversation about it. If they were around when something happened, they're an unindicted co-conspirator, and so their statements automatically come in. And I reject that. If they believe that Bentley was involved in the commission of Nutt's murder, they could have indicted him and charged him just as a co-defendant, as opposed to what they're arguing now as an unindicted co-conspirator. So I'm going to rest on all the arguments I made previously and ask you that these items be kept out.
Okay. All right. The court's had an opportunity to consider both arguments of counsels for the defense and for the state in regards to lines 488 line 1 to 491 line 10 and the corresponding video and audio marks that have been stated for the record already. In this particular period, talks or references where Mr. Copeland reportedly talks about Nutt's murder based upon what he heard and what he thinks and what he opines from the defense's perspective, and their basis for their exclusion are hearsay, confrontation, speculation, lacks foundation. Mm-hmm. The state has responded by saying that they have in fact laid the foundation. They've also indicated that for a period of this where you have conversations in regards to what Mr. Garlington told Mr. Copeland, that those would be admissible under co-conspirator statements, which the court's ruled upon already. The other basis is prior inconsistent statements. The court is of the opinion that based upon what the court has heard from direct testimony, that in his direct, he says in pertinent summation that he doesn't remember what happened in the car, or he went blank, or words to that effect. Without having a transcript, I can't say the exact words, but the court is of the opinion that the state has asked a predicate foundation to explore from Mr. Copeland impeachment, at least impeachment by contradiction or prior inconsistent statements. So I'm going to omit those allow the state to play that portion of the tape over a defense objection. Mr. Adams, I will give you and others a continuing objection.
Thank you.
And that does not include the omission of page 490, line 1 through 12. That's Mr. Stillwell's statement, which are
I'm gonna
to
go
be
back a
omitted by
second,
agreement
guys. I missed
by
what
the
he
state
said.
and that's of Mr.
Thank you.
and portion of the to Copeland impeachment, at least impeachment by contradiction or prior inconsistent statement. So I'm going to omit those.
All right.
Allow the state to play that portion of the tape over a defense objection. Mr. Adams, I will give you and others a continuing objection.
Thank you.
So he gave this. That was a win for the state. I mean, if you guessed it, you guessed it. That was a win for the state. But he is omitting certain parts. So it's kind of like a partial win for them. But when you hear the continuing objection, that means that he has to note it for the record. So if it goes up on appeal, Glanville, you let it in. And shout out to Judge Glanville's cough, who says good morning, AV and chat. All right, guys, let's go back in.
And that does not include the omission of page 490, line 1 through 12. That's Mr. Stillwell's statement, which are going to be omitted by agreement by the state and Mr. Sharp. All right. Okay.
Yes, sir.
All right, let's move on to the next one, please.
The next one is, if we jump down to, is going to be page 499, line 14 through page 500, line 6. In those excerpts, if the court will take a look at it, the detective essentially, it's mostly the detective speaking. Mr. Copeland has a few lines in there as well, but it's mostly the detective speaking. And the detective is giving what I would call a speech about how they want Mr. Williams, how Mr. Williams is using others for his, quote, their words, reign of power, and how Mr. Williams eliminates people or his enemies. His enemies is my
Hi,
verbiage.
Lucy.
People is what the detective says.
Merch link in the description box.
If
What
we
you
look
mean?
at line 14.
On page 499?
Page 499, yes, sir.
Okay.
The detective Dennis is talking. He says, you want to know what we want? We want the stuff to stop. If y'all were just making music, I like rap music. I like some of Thug's music. I think it actually says every now and then. Transcript says if he has any. Mr. Copeland just replies, yeah. Detective Dennis goes on and says, but that ain't what's going on. That's a fake card for indiscernible, all this other stuff. That's the detective talking, giving his opinion. Mr. Copeland responds, it didn't start until we got Thug. And then Detective Dennis responds, exactly. He basically used y'all as his gunners to help him get this reign of power. Nut, get out the way. You're a threat. Anybody that's a threat, he eliminates them. So at what point do y'all figure out that y'all can be eliminated too? He don't care about nobody but himself. What it sounds. Ms. Copeland says, oh, well, that's what it is. Detective Dennis says, so why would you stick around and let this man bring to your demise? So I'm going to go back to some things I say often. Sounds to me like, it seems to me that this is an easy one, right? The state is going to disagree. But this is Detective Dennis. None of this is relevant. The detective's thinking about, what Mr. Williams's music means or what type of person, what his character is absolutely not relevant. There's nothing that this adds to the case. There's nothing that this adds to any. It's not an item of evidence. It's just the detective's opinion. Wherever he gets his opinion from, whatever he forms that opinion based upon, that's him. But it's not relevant. His opinion is not relevant. It touches upon Mr. Williams's character. It defines Mr. Williams' character in a way that is impermissible. And again, it's not based on any fact or evidence. It's based upon his opinion. And it's a commentary upon Mr. Williams's music and what it means, which again is the detective's opinion that has no relevance whatsoever for the jury's consideration. And so just based upon that, And of course, doesn't give any foundation. I guess I'll throw that word in there, foundation, for where the detective is getting this opinion, other than just that's what he thinks. His opinion is more prejudicial than probative. I would say it's not probative at all. And so I'd ask that it be redacted.
The hearing got
Right.
rescheduled,
So-
guys. And he's arguing Rule 403. I'll explain in a second. Let's see what she says. Here comes Miss Love.
Of course not.
All right.
Your Honor.
Let the micromanaging begin. As we can see, Miss Love is
Your
back.
Honor, the state will agree that beginning at line 23
On what page, ma'am?
of page 499 to page 6 of 500.
You mean page 6 of 500 or?
Page 500, line 6, I'm sorry. So page 499, beginning at line 23, where it says Detective Dennis, exactly, he basically used y'all as his gunners. Through page 500, line 6.
Okay, tell me why you think that I should,
The state has no objection to that portion being redacted.
that the line 22 of page 499,
No, line 23
line 23
of page,
of page 499, so.
yes, through line 6 of page 500.
To page 500, line 6.
The state has no objection to redacting that portion.
Okay, let's talk about the I guess the rest, the from line
14 through 22.
Yes, ma'am.
Your Honor, in line 14 through 22, detective, well, let's go a few lines before this. Prior to this particular statement that Mr. Investigator Dennis says, they're still talking about Copeland's kind of concern still about being labeled a snitch. And who, he's in this space of, what do I do? If I tell, then the streets aren't going to like me. If I don't tell, this could happen to me. And what Detective Dennis says to him is, we want this stuff to stop. If y'all were just making music, he says, I like rap music. I like some of Thug's music every now and then. Copeland says, yeah, but that ain't what's going on. That's a fake card, all this other stuff. And then Copeland says, it didn't start until we got with Thug. This line is in direct contradiction to the defense's assertion in opening that the focus of their investigation was all about Young Thug and his music, that we attacked as the state, as the police officers, that we were only focused on using these lyrics and this music, and then we created a case solely based off of the music. And this is in direct contradiction to that. In the course of the investigation, the investigator Dennis, is telling Mr. Copeland, this is not even about the music. Matter of fact, I like some of his music. This is about what has been happening in these streets, what the shootings that have been going back and forth for now, at this point, 6 months, and putting it into that and encouraging Copeland to continue to tell the truth about what has happened. And then Copeland's response to that is, this didn't start until we got with Thug, until he, I believe, when the we is him, Demekian, and Shannon, that all of this violent stuff started happening. And it's not just about the music. And so we believe that this is in direct contradiction to the assertion that the police officers were solely focused on music and lyrics in this case, but no, they were focused on stopping crime, and it had nothing to do with the music. So for those reasons, Your Honor, we believe that that portion is relevant.
Mr. Adams?
So the only thing that's, two things. Number one, I think we all know that what is said in opening
Not
and
evidence.
not evidence, questions by the attorneys aimed at getting at a certain point, not evidence. And so what they have to prove in court, they have to prove by way of evidence. What the detective says in this excerpt, and we're talking strictly about line 14 through line 22, this is the detective's opinion on what the music is or is not. So for example, if you look at line 19, when he says, but that ain't what's going on, that's a fake card for all this other stuff. Well, if that's the case, then let's prove it with evidence as opposed to giving the jury the detective's opinion as to what that is. Because without more, what the jury ends up getting is the detective's soliloquy on what he thinks the music means, whether or not it's being propagated for art, or whether or not it has something indeed to do with the rest of the case or any of the criminal activities that have been indicted. And they've got to prove that with evidence. I just don't think that there's anything here. I don't think number one, his opinion is not relevant in regards to this item of evidence. And I think there's a fair amount of speculation on the state's part. I've said it before. I understand they have their theory, but when Madam Prosecutor says that Mr. Copeland's response, it didn't, on line 22, it didn't start until we got thug. When she opines, well, when he says we, he means Shannon and Demikian, and this is who he means. Well, they don't know that. They don't know that any more than we do, unless Mr. Copeland gets on the stand and says, hey, this is what I meant, and this is who I'm talking about. That hasn't happened yet. So that part is just speculation. But overall, these few lines that we're talking about is nothing other than the detective's speculation as to what he thinks the music is in his opinion. And that's not relevant and should not be allowed. Yes, one more.
Sure.
Sorry, I was muted. Guys, before he continues, I just wanted to quickly answer some of your questions as they come in. The hearing that was scheduled for yesterday got rescheduled to July 3rd. Okay, so that's why it didn't happen. A few of you guys have been asking, and I've been jotting down your questions, but also to answer Integrity's question here. He says hearsay, is it always when someone else claims someone else told them something else? Is it one of those statements? No, there are exceptions to hearsay, right? There are opportunities for hearsay to come in. With the hearsay rule, it falls under 801 of the Federal Rules of Evidence. Guys, there are 30 exceptions where something could be hearsay, but it could still come in as evidence. And I'll break that down after his argument here, but they're trying to keep this particular part of the conversation out. Let's go back in.
Also regarding this, the state is making the argument that this out-of-court statement should be played because of arguments that some defense counsel made during opening statements. My recollection is that certainly that Investigator Dennis has been on the stand, and he provided live testimony rebutting the defense argument about following lyrics, and instead said, no, we follow crime and then found lyrics. I believe that was Dennis. It may have been Gaither. Anyways, the state has provided live testimony regarding that issue and their counter to whatever was argued in opening that they say was argued in opening. So I don't know why we would, knowing that this has been argued through live testimony, I don't know why we would allow out-of-court statements, hearsay statements that also have problematic parts in speculation, as Mr. Adams has stated. I don't know why we would allow that into evidence when the state has already been allowed through live testimony to address this issue.
I agree with this one. Shout out to Harlem.
And if I may just add very briefly, I also think that this is probably not necessary because, as I stated before, with setting opening and the questions of the attorneys are not evidence.
But now the other thing I was going to mention, Mr. Sharp just reminded me, The court is very aware that you are not required to present any evidence at this point in time. You have not elected that decision, and that's of no consequence to me what they're saying you've said. You said. So I'm not taking that from that vein at all.
Also true, and I do think it is, and I know it's been a long time, because we did opening back in November or whenever it was.
Yeah, that was November, I think, yeah.
You know, but I think that the state isn't remembering correctly what Mr. Steele said in opening. I do recall that he made reference to the state cherry picking lyrics and so forth, but again, so I think their recollection of that is incorrect, but I don't think that's part of the calculus or the consideration at all, because it's not in this.
Right.
You're right, so I have just probably about those last two.
Sure.
So first, as it relates to the fact that the state cannot rebut what is said in opening, and looking at 24-6-621,
24-6.
621, which is impeachment by contradiction. Also in reading Carlson's on page 351, which is citing to federal law. Federal courts allow parties to counter misrepresentations and in an opponent's opening statement with contradictory proof.
What
This-
page down, I'm sorry?
Page 351.
What part of it?
If you go to,
I see it.
The
I see it
third-
about the fourth paragraph down.
yes, Sam.
Okay.
And rebuttal will sometimes mean the countering of factual assertions made during defense counsel's opening statement or for them cross-examination of the government witnesses. So the state can bring in evidence to rebut what was said in an opening statement. But furthermore, Your Honor, this statement, what investigator Dennis said about the music is an adoptive admission by Mr. Copeland. Mr. Copeland does not disavow that this is just about making music. He, matter of fact, agrees with Detective Dennis. And in court, if you can recall, Your Honor, Mr. Copeland made it seem that YSL is just a music group. Matter of fact, I think he even said the only gang that he associates himself is 372, that he's not even a part of YSL. When I asked him directly, are you a part of YSL, the gang? And he disavowed that. So when you look at what he's testified into court about his disavowment of YSL, that YSL is just a music group, that this is in direct contradiction to that assertion. And he adopts what Detective Dennis says by not disavowing it, not saying, no, it's only about the music. He says, yeah. And matter of fact, he further says it didn't start until we got with Thug. So, Your Honor, for those additional reasons, we believe that this portion, page 499.
We got with Thug or we got Thug? That's what this transcript says we got Thug.
I think when you listen to the recording, it says until we got with Thug.
Let me listen to that portion, please. I just want to listen from about line 14 to line 22.
Okay. Yes,
Mr.
Your
Sharp,
Honor.
you have something else?
Well, it just occurs to me that this adoptive admission argument.
Don't worry
I
about
mean,
that.
not only are
Don't
we,
worry about that.
okay,
Okay, don't worry about that. I mean, I'll let you complete your argument if you want, but I'm not convinced it's an adoptive admission, okay?
All right, guys. There.
All right. Okay, all right.
Let me attempt to convince the court also by just looking at 24-6-621. What it actually says is a witness.
Yeah, that's why I'm not convinced, okay? All right.
All right. So we're going to listen
Okay.
to Lil Woody in his with the detective. Warning: the audio is bad. I'm just letting y'all know.
Timestamp 5:44:34.
5:44, 33 to about what time?
To about 5:44:50.
Okay. Hold on.
All right. This is evidentiary piece 2 out of 6 today. He wants to hear it before he rules on it. And again, just letting y'all know the audio can be louder. So, warning. I jumped in too late, Willie.
And then I won't tell them, keep coming back telling them, I will talk to the police, I will talk to the police. And they just feel agent, ain't nobody locked up, everybody got no warrants. So I went and take that because the truth is, everybody say, I can't be telling that because whatever I know, they get locked up. You know what I'm saying? Right. So they know that. And they ain't get locked up, so they know, well, I ain't tell you. That's the only thing they keep me out of it.
But what happens when they start getting locked up?
So what I'm saying, that's why these
Started much earlier.
She's rewinding so we can hear it again.
I'm going to restart at 5:44.
I know.
You wanna know, we want the stuff to stop. If y'all was just making music, I like rap music. I like some thug music every now and then.
Yeah.
But that ain't what's going on. That's a fake card for fueling all this other stuff.
It didn't start till we got to it.
Exactly.
Yeah.
One more time, please. Christina?
Whew. Oh my God. That audio is
Anybody else who
terrible.
wants to listen to it, you're welcome to come up and listen as well. What?
I think she's trying to use this to convince the jury that YSL is a gang and it's not just about music.
Ready on?
Not yet. Not yet. I'm almost ready.
Thank you for the clarification, Kat. I did not know that she.
Fish. That's not to insult you. That's being real. Like,
I know.
you wanna know, we want the stuff to stop. If y'all was just making music, I like rap music. I like some thug music every now and then.
Yeah.
But that ain't what's going on. That's a fake card for fueling all this other stuff.
It didn't start till we got to it.
Exactly.
Yeah.
Okay. Detective Dennis on lines 14 through 16, part of it is I like some of Thug's music now and then, or to that effect. It's not if he has any. And then on line 22 of 499, it does say when it didn't start till we got with Thug.
But what does that mean?
I don't know. I'm just listening to it. Okay, so Jenny, you want to listen to it as well? I mean, I give you the opportunity. Give the opportunity to do so.
I don't disagree that what's in the transcript is
It's not quite accurate. It's close in regards to that particular portion of what Detective Den starts off with. Okay.
Thank you, TT. I agree. I don't think the statement should come in.
All right. Based upon the court's listening to this particular portion of lines 14 through 22, the court is of the opinion that it is opinion by Detective Dennis and it is speculation. So I'm going to exclude it.
All right.
At this time.
Win for the defense.
Omit it.
This is
Just
coming
that
out.
particular section.
Thank you, Your Honor.
All right.
Can you give me the timestamps starting at line 14 to line 6?
So it should be 5:44 at 34.
You said it was 29 earlier.
Well, I started at 23, so I'm going to say 5:44 29 approximately to 5:45
28.
23.
544, 29, 545, 23.
Yes.
Okay. Any further argument or discussion in regards to that portion? Okay. All right.
Next one.
All right. We're moving on to 3 out of 6.
1 second.
Here's that dog. So we're moving on to piece of evidence 3 out of 6 that is under review today. It should be a short court day.
All right, sir, I'm with you.
Yes, sir.
Guys, for your
523.
Yes, 510, line 4 to page 511, line 3.
Okay, 510, page, line 4.
Yes, sir, to page 511, line 3.
Okay.
There's a conversation between the detective and Mr. Copeland. Essentially what they're doing is they're talking about who to go after first. And there's some opinion as to who they should go after first. Opinion about Shannon, opinion about D, and opinion about Doo-Wop. In relevant part, I'm going to just kind of read through from line 4. Detective Thorpe is speaking, and he says, so let me ask you this. Of all them, I think he said clowns. Of all them clowns you just named, who do you think the first person I should go after? Mr. Copeland responds, to lock up or to talk to? Talk to. I would say Doo-Wop, but if you go after him first, they're going to have a feeling somebody told. You feel me? That's an opinion. Detective Thorpe, so who do you think I should go after first? Mr. Copeland says, B, truth be told, I want to say Shannon. You feel me? Because when he said this indiscernible, I think it says got locked up. Because when we got locked up, Shannon looked like he wanted to tell. You know what I mean? Tell on them. Again, an opinion, speculation on the part of Mr. Copeland. Detective 1, yeah, but that was years ago. How you feel about little D? Like since D was the one that supposedly wasn't shooting, but he came and told you. Ms. Copeland says, D thinks he's hard. This is opinion. Detective 1, so he probably wouldn't just because he thinks he's hard. Mr. Copeland says, right. When I gave him your number and then y'all let me go, I was looking at him like, damn, D, like he the one, he knows I gave him your number, bruh. You ain't have to go tell everybody. Detective says, right. Ms. Copeland says, you know what I'm saying? Like he indiscernible on me. That's a little further. I think it stops at line 3.
Just popping in because we are now on the 3rd piece of evidence, and Attorney Adams for Young Thug is moved to the front of the courtroom. So thank you, peace, love, and prayers for the question. He is still, the table for Young Thug is a little bit farther away. They've been having audio issues throughout this entire trial. I think Adams is sitting up there because that is a table that has a microphone that functions, right? The one that is back where him and Steele are sitting, I don't believe works. That's why he is sitting up there. He sat up there yesterday as well. As far as this 3rd piece of evidence, it looks like this is another conversation between the detective and Lil Woody. In fact, they were talking, and he basically said, the detective says, hey, who should I go after first? Lil Woody says you should go after Shannon because he looked like he would tell or he would give you some information. Now, they want to take this out. Adams is using 2 arguments for this one. He's saying that was Lil Woody's opinion, right? It's not a fact. It's not a legal fact, right? And then the other thing is, the other argument he's using is speculation. That's why he wants to take this piece of evidence out. Let's see if he wins on this one.
But it's clear that whole colloquy from the previous page, 510 to 511, is all a matter of speculation. You know, what the detective is asking Mr. Copeland as to who they should go after first, either to talk to or to arrest, there's no way that there's any relevance to that. Mr. Copeland's opinion, speculation as to who might talk or who might not, regardless of what he knows about those individuals, is in fact speculation, it's opinion, and it's not relevant. So my objection to that colloquy on that page and a few lines would be that it is improper speculation, impermissible speculation, and irrelevant opinion, and it should be redacted. It simply has no relevance whatsoever.
All right, sir. State.
Yes, Your Honor. This is very relevant. Again, the defense's theory about this case is that they didn't do any investigation. They didn't do anything. All they did was take what Copeland said and ran with it. And what this shows is that the detectives were trying to speak to other individuals in order to corroborate what Copeland told them. And so they are asking Mr. Copeland his lay opinion on who out of these individuals he should talk to. So I know we keep throwing around the word speculation and opinion, but a lay witness can give their opinion if that opinion is rationally based on the perception of the witness, which is 24-7-701. Mr. Copeland knows the individuals to whom he's been talking about. He has spent time with them. He is friends with them. He considers some of them like his brothers. We have pictures of them together. So he can, based upon his own opinion, can say, this is who I think will talk to you all, based upon his interactions and his lay opinion, Your Honor. So the fact that he tells them, here's who I think you should talk to, here's who I think will talk to you, is a proper opinion that he can give.
It's speculation.
And it's clear that it's an opinion because he talks about Duwop versus Shannon versus Demikian. And he tells them, here's who I think you should go to first. But if you go to this person first, they're going to know that I told something.
Can I ask you a question?
Yes.
Or hijack you just for a second.
Sure.
Did you ask Mr. Copeland about this on direct already?
Ask Mr. Copeland
on direct about any of his discussions with Detective Dennis in regards to this part of the investigation. I don't recall it being asked.
About if he told the detectives who he should speak with in regarding this case. I don't believe I asked him directly that specific question.
Right. I'm gonna exclude it for foundation right now. I'm not saying it may not be admissible for other reasons later, but I agree with Mr. Adams. It is speculation and opinion is not relevant under 401 at this point in time.
Wow.
However, having said that, if somebody opens the door as to it, or if you continuing with your direct examination lay a foundation as to ask him any about that, then I'll reconsider.
So I guess my question is, if I ask him, did you advise law enforcement who they should speak to? There's going to be a lay opinion objection. When I'm saying it's not a lay opinion,
well, it still might be speculation or opinion because it's got to be based on something. You're saying it's based upon he knows these people. Right. And he's got them, but you'd have to lay the foundation to ask that question. But
I think we have laid the foundation, or we've established.
Here's the thing. Ooh. I don't think you get covered because he says, I don't recall, or I don't remember. I think you still got it, as I mentioned to you yesterday. With all due respect, you still got it since you haven't asked him about it yet. It wouldn't be proper to just play this. However, if you can lay the foundation based upon the argument you just told me, I'll certainly consider it at that point.
And I guess I want clarity because I think we've laid the foundation that he would have a proper basis to give a lay opinion.
I don't know.
We believe that.
I need to again. If you lay foundation as to a lay opinion, I might be able to rule upon it. I don't know whether or not that will carry the day or not, but it depends on how you ask Mr. Copeland those questions and his response. I'm not, like I told you, I'm not saying that it may not be, but not right now.
All right.
So I'm gonna exclude that for the time being for foundation, but in the arguments of Mr. Adams, and like I said, I'll come back to it if you remind me at the appropriate time, and we'll look at it.
All right. Okay. Win for the defense.
All right. Yes.
That is going to be 554-22.
554-22.
Through 555-19.
All right.
555.
4 out of 6. We're moving in.
555-19. All right. Any further discussion? Okay.
The last one, Judge, is page 512, line 18, to page 517.
All right, guys. So just a quick explainer. Adams won that last argument. So that was, we are on 3 out of 6 so far. So we're actually moving quite fast this morning. So they'll probably end court a little bit early because there's 6 pieces they're supposed to be reviewing. It looks like Adams has gotten 2 of them out so far. So that's really good. For the defense team and the prosecution team was able to hold on to 1 thing earlier. So we'll see. We're moving on to evidence piece number 4. Let's see what they're going to talk about right now and which part of Lil Woody's self-snitching is coming in.
Line 19.
And Your Honor, based on your previous ruling, I think that this covers that same area about who they should speak to. So, given your current ruling,
Okay.
the state will just address it at that.
Let me have the time. Let's have the time markings as well. So that will be excluded for foundation as well at this time. At this time.
And that was going to be the same one.
Okay. All right.
5:56:18
5:56:18.
through 6 o'clock in 3 seconds.
So what is that?
6:00.
6:00.
03.
Okay. All right.
That's it, Judge. That's all that we have on behalf of Mr. Woody.
Okay. Before I return to Mr. Sharp for the 2 ones that we may have, and I think I asked the state about those. So let me get to that place and let me get to it.
Jay, that meeting got rescheduled to July 3rd. So she's got to travel back on July 3rd. Super inconvenient. Oh, I'll have to do a whole video on hearsay, guys. 30 exceptions. I don't think so. It is what it is. He's definitely part of the prosecution's team, but sometimes they're there to help with research and to pull cases. But Hilton is going to be the primary speaker with her boss behind her, watching everything she's doing. Thank you guys for the likes. You're doing a great job here. Really appreciate it. I would too, Jeremy. He's their star witness. It is Frank. She is Sophia. Shout out to Judge Glanville Service Dog in the chat. He needs a recess. Thank you, Furpo. Okay. They've muted the feed, guys. Let me see if we have some TiVo time. Let's get through that. They probably didn't want us to hear all the page flipping.
That's our talk, and I think that there's 2 that we may need to discuss or talk about again in regards to your client, Mr. Stillwell. Mr. Weinstein, anything else in regards to June 10th interview? All right. Mr. Matthews Jr., anything else in regards to June 10th? Okay, and good morning, sir. All right, Misty Williams. All right, Mr. Botts, on behalf of Mr. Nichols. All right. Okay. Anything further? Now I'll turn to Mr. Shark.
Yes, sir.
I think that you were going to take a look at your notes or whatever in regards to for 2 particular areas. So have you done that so far, sir?
Well, I think we tabled it to, I don't know if I was necessarily going to look at my notes, but I've given those issues some thought, but I think we tabled them for further discussion.
Are you going to wait until they're played to object, or Or do you want to, can you identify them for me so I can rule upon them?
I have them, Your Honor.
Okay.
I believe it was,
Tell us what the page reference was, Ms. Hilton.
I think it's page 361.
That's one, line 1 to 362, line 10.
No, I had line 15 through 17, Your Honor.
That's the one where I think it's problem is Shannon. Is that correct?
Yes, and I believe the court wanted me to go back and listen to and determine if I asked questions.
Yes.
Okay, so we just finished all of the 6 for Young Thug, right? He just went around the room and asked the other attorneys if they have anything else. We're now back to Attorney Shard for Shannon Stillwell. It looks like we've gotten through Shannon's stuff, but there's 2 more that they didn't finish yesterday. So we're going back to those right now. So it looks like it's they're moving along in court today, which is good. Usually this is a very slow process.
And, all right. That was 1. Okay. And did you review that, madam?
Yes, Your Honor, and that's consistent with the portion of the transcript that I just recounted in the argument with Mr. Adams about when Shannon got into the vehicle. Again, Mr. Copeland's current version of facts on the stand is that Shannon got into the vehicle with him and Little D at the McDonald's.
All right, let me take a look at that right quick.
Little Woody will be back, I think, after the 4th of July.
This is regarding page 361.
Yes, line 15 through 17. And I believe the portion that's at issue is where he says Shannon shot Nut is what the court wanted to hear if I had asked him questions about the murder of Donovan Thomas.
Can I just go back and make sure we're on the same page with everything leading up to this? Because, Your Honor, I too know what Ms. Hilton's speaking of, but I also had in my notes 361 through 10. So
No jury today.
361 line 1 through 362 line 10.
361 line 10 to 362 line 10.
Okay, I originally had line 1. All right, so okay.
So 361 line 1 through 12, we'll say, state has agreed that that's coming out. Is that correct?
No.
Steele is right
Okay,
there,
so all of this
sitting next to Thug.
No, from what you gave us originally, the only thing that was in dispute was Shannon shot up Lil Wayne's tour bus, Shannon shot Nut, Shannon does whatever Thug says.
On my list, it says page 361, line 1 to 362, line 10.
All right, so is the state agreeing to a portion of this to be redacted, or what are you saying?
The only portion that we agreed to be redacted is on line 16, Shannon shot up that tour bus.
Okay.
Line 16, and that's on page what, madam?
Page 361.
All right, and
it says the specific sentence is Shannon shot up that tour bus. And I believe, Your Honor, on Monday, you were holding off ruling to determine whether or not I had asked Mr. Copeland about the murder of Donovan Thomas. And you wanted me to confirm with Madam Court Reporter that I did ask Mr. Copeland while on the stand about the night of Donovan Thomas's murder.
all right. Specifically, what did you ask him? Because I do recall you did ask him about that, but remember, consistent with my earlier statements, that what exactly did you? Because this particular, let me just kind of.
Shout out to Classy.
All right.
Yes. So do you mind if I keep my seat, Your Honor?
Yes, ma'am. You can keep your seat just as long as you speak in the microphone. That's fine.
Yes. So it starts After you left Mechanicsville, did you go anywhere after leaving Mechanicsville from what you remember? Yeah. His response, yeah. Question, do you remember where you went?
This is your examination.
Yes, Your Honor.
Okay, all right.
Pick little D up. Question, okay, and which little D are we talking about? Answer, the one that always be with me. Is that the little D you reference as your son? Yeah. Okay, do you remember where you picked little D up? Where did you pick little D up at? Answer, at McDonald's. Where was the McDonald's? On Cleveland Avenue.
Guys, we got to stop the show for a second. Do me a huge favor and type Mike in Tennessee in the chat. Mike in 10, thank you so much. This is extremely generous and very sweet of you. Guys, Mike in Tennessee had found me in lead recently. He has been supporting me. He has been in the comment section. He has been dropping links to all my social media. He's such a great guy. If y'all could do me a favor and type Mike in 10, that would be fantastic because he is your stream sponsor. He is the person that is sponsoring today's stream. Extremely generous. I know many of you have dropped super chats. I like to read them on a break so that way we can get through the whole content. But when somebody blesses me like this, I need to stop the show and make sure that they are properly acknowledged. Very, very generous of you, Mike. And here's what he says. He says, thanks for all your hard work breaking down these cases for all of us. You are appreciated. Keep up the great work. And yeah, guys, me and Lead are a team. I do a lot of work on his side, but from time to time, we're going to need to take breaks, and I'm going to be doing stuff on my side too. And it's always a great time to go over there, but it's also great to do it on this side as well. So thank you guys all for subscribing and shouting out Mike in the comment section or in the chat. I really appreciate that. Make sure you type in Mike in 10. He is your stream sponsor. Thanks again, Mike. Very, very generous of you. Let's go back in, guys.
And when you got to the McDonald's on Cleveland Avenue, was there anyone else with little D? Answer, just him and Shannon. Anybody else? Just him. It says have Shannon, but just him have Shannon. When you picked up little D, what did Shannon do? What you mean? You said you picked little D up. Did you also pick up Shannon? I said I picked up both of them. Okay. When you picked up both of them, where did you all go? I blanked out after that. You blanked out after that? Why did you blank out? Because they were saying that I got phone calls saying I did something. Do you remember who called you? Yes. Who? Muntsung. And do you recall how he called you? Did he call you on FaceTime or did he call you on the phone? I don't know. He asked me what I got going on or if I heard what happened or what. I don't know what he said. I just know he said that. People saying I killed Nut and he was calling me. Now let me ask you this. Did you kill Nut? Huh? Did you kill Nut? No. Okay, now when Muntsung calls you, was both Shannon and Little D in the car when Muntsung calls you? Huh? Was Shannon and Little D in the car when Muntsung called you? I think so. Now, before Muntsung called you, did you, Shannon, and Little D have any conversation about Nut being killed? No. Now, after you got off the phone with Muntsung, did you and Shannon and Little D go anywhere? Huh? You said you were on the phone with Muntsung in the car. I blanked out. Like, I know I ended up in a whole lot of places. Every time I looked around, I was somewhere different. Okay, later that evening, as we talked earlier, did you go to the police department? No. That night that you learned about Nut's death, Muntsung called you. At any point, did you go to the police department? Oh, yeah. And then I believe at that point, Mr. Steele may have objected. And then I go into, on the morning of January 11th, did you ever speak with police? There was another objection. I asked the question again on the morning of January 11th, did you ever speak with police about Nut being killed? The police called me. Did you go to the police department? Same objection. Did you go to the police department, speak to the police? Yeah, I think. I asked them, how did you get to the police department? I dropped him off. By who Muntsung got me, I ain't for sure. I can't recall. But I think who dropped me off, I just remember my brother and then met me down there that night. I said, now, Mr. Copeland, today being June 13, 2024, prior to today, I want to make sure I understand. Have you ever told police that Little D and Shannon got into your vehicle? Mr. Steele objected. The objection was sustained. Is today the first time you told the police or told anyone? And then the court interjects at which day? Today, June 13th. Let me strike that. Yesterday, did you tell me and my colleagues that Shannon, objection leading? I'm going to overrule the objection. Yesterday, did you tell myself and my colleagues, Ms. Love and others, about Little D and Shannon being in your vehicle the night of the murder? Yesterday, did you tell myself, Ms. Love, and a few of my other colleagues that Little D and Shannon were in the car with you the night of Donovan Thomas' murder? I told you and them that what I told the investigators when Nut got killed, something different, because I was trying to finesse my way out of the situation. Okay, so I said, I picked up D and Shannon. D never told me nothing. I made it up to clear myself up, and that's it. Okay, and was that yesterday that you said that? Did you tell us that yesterday, what you just said? You asked me to be truthful. So again, anything that, and that's the end of the transcript as we have it. So again, he told me in court that D never told him anything, nothing. So anything that D told him back, that he told police D told him, would be impeachment by prior inconsistent statement, impeachment by contradiction. He said, I made it up to clear myself, and that's it.
You sure?
That's not true. The state's skipping a step.
Ooh.
First of all, impeachment by contradiction is bringing in, it's not supposed to be prior inconsistent statements. That is.
No, it's anything that the witness testifies inconsistently with earlier. I mean,
Well,
so
respectfully, that's what prior inconsistent statements are.
it can be.
Contradiction, Your Honor, is witness named Jeff says the light was red at the time of the crash. You bring in witness Brian that says no, the light was actually green at the time of the crash. That's impeachment by contradiction.
Here comes the
Bringing
micromanager.
another witness to testify about how the first witness was incorrect or wrong or contradictory. Prior inconsistent statements is a type of impeachment contradiction using a witness's prior statements. And so what the state is missing here is they're saying, did Demekian, they're saying the foundation is laid by saying, did Demekian, was Demekian in the car? Did Demekian say anything? Kenneth Copeland is saying no. But that's not the correct question to lay the foundation for prior inconsistent statements. They need to say very specifically, they need to ask, did you tell police that Demekian Garlington told you this on this date? That lays the foundation. And they're also confusing the issue by including Shannon in these conversations, which has never been said by Mr. Copeland. So if they say, did Demekian and Shannon, did you tell the police that Demekian and Shannon told you that so-and-so, whatever happened on January 10, 2015, he would be correct to say, no, I never told the police that. And there would be nothing inconsistent.
Start turning up.
He has never put Shannon as a party to any of these conversations. They need to specifically ask, did you tell the police, not did it happen, but did you tell the police that Demekian Garlington told you this?
Yeah, she does
And
need to
if
ask
he
him
says
that.
yes, then they don't get to get in these prior statements because they're not inconsistent. The question isn't, did Demekian tell you this? It's, did you tell the police Demekian told you this? And if he's asked that question, he may very well say, yes, I did tell Demekian that. It was all I did tell the police that Demekian told me that. It was all a lie, but I do acknowledge.
Y'all are really blessing me today. Mike in Tennessee, thank you so much. But ladies and gentlemen, we have a new stream sponsor. Can all of y'all do me a favor and type in Jazma? Jazma, thank you so much. She drops $200. No comment, no question. Pure love of the game. Jazma, thank you so much. And number one, you have a beautiful name. I love your name. I've never seen it before. It's very unique, very pretty. And your stream sponsor, guys, is a female. I want to acknowledge that. Thank you so much, Jazma. And completely generous of you. You know, when you guys bless us like this, it really keeps us motivated. Like, I cannot tell y'all the types of comments I get in a day. I cannot tell you guys, like, the internet is crazy. Sometimes people, can say some really egregious things about you, especially being a woman. You know, like you'll get some unsavory male comments from time to time, but also, you know, you'll get a lot of people that cheer you on. Like these are the ones that keep you going as a content creator. So Jazma, number one, thank you. I can't thank you enough. And if you guys are not spamming that in this chat right now, please do it. Please do it. She does not have to do that, but at the same time, it just shows the generosity that is here in our community. You know, I'm so grateful for it. You know, I read a comment yesterday on Lead Stream. There's a gentleman that was just like, Avi's a brat. She's entitled. I was just like, wow, dude. You know, like I really, you know, I spend a lot of time here. I take a lot of time out of my day to sit down with you guys and explain how the law works, because you know, it's interesting. You could watch this stuff on court TV without the live commentary and not know what's going on, you know, but I also do it because I really find a lot of joy in doing this. And again, guys, I apologize. The window is open. I live near the ocean up here in Boston, or at least my family does. And there's a lot of birds. So shout out to the birds. But Jazma, thank you so much for this super generous super chat. I can't thank you enough. She is you guys' stream sponsor. She's the power behind this stream. So Jazma, thank you. Thank you so much. I can't thank you enough. And well, let's go back in, guys, and see where we are. But Sharf, Attorney Sharf right now is doing an excellent job. He's actually making a really, really good point. The point that he's making is that the state is trying to just, you know, because they couldn't get Lil Woody to cooperate, they want to play all these things. They want to play all of these pieces of evidence, which is cool. But to an extent, you're also wasting a lot of time with something like this. And here's the thing. He's actually kind of schooling Miss Hilton there, because he's like, you didn't ask the question properly when Lil Woody was on the stand. You didn't say, hey, did you say this to this person? Because that's the hearsay part. She has to word it differently. Like, did you say this to the police? Did you say this to the detectives, right? So he's actually doing a really solid job with how he's explaining this, right? So this is a good argument. Let's see if he wins, because this is Sharf trying to keep something out that is in regards to his client, Shannon Stillwell. So let's see, because he's gotten a few wins this week. Let's see how he performs here.
Telling the police that.
Thank you again,
in which case,
Jazma.
there's no prior inconsistent statement, because he is acknowledging that he made that statement in the past, and it doesn't need to be proven using extrinsic evidence, including a videotape. But they haven't done that. They've just asked did it happen, not did he tell the police that it happened.
What if, as in this particular circumstance, I think that there's an omission. Like he says, hey, I don't recall this, and then his earlier statement says, you know, includes more people or is more or has more granularity.
Well, the problem is they asked, did Demekion and Shannon discuss this in the car? And he has never said Demekion and Shannon discussed anything in the car. He said, what he said in his prior statements were, I showed at the McDonald's. Demekion was the first person to come to my car. Demekion got in my car, said something very quick, pointed at the people who he said did it, and then didn't say anything else. That's what he said. He never said Shannon Stillwell was in a car discussing anything. And the reason he never said it because Shannon Stillwell was never in a car discussing anything. So be very specific.
Okay.
About what they're saying he said in the past. And if he owns that prior statement, then this doesn't get in.
All right.
Your Honor, but that's the point, Your Honor. We agree. He never told the police that Shannon was in the car. So he is contradicted by what he told the police previously. And he said, and I don't have to ask him again, his answer was, I told you and them that what I told investigators when Nut got killed, something different, because I was trying to finesse my way out of the situation. He has already admitted right there that what I said to the detectives in 2015 is a lie. It's not true. I finessed my way.
That's your problem, though.
And it's inconsistent with what he is now saying in what he said back then. So that's a prior inconsistent statement. Furthermore, to address what Mr. Shar just said about extrinsic evidence, when it comes to impeachment by contradiction, Impeachment by contradiction occurs when a party offers evidence to prove that a fact to which a witness testified is not true. And it can be done by extrinsic evidence. The recording is the extrinsic evidence that we can bring in to show that what he said in court is not true. This is the extrinsic evidence. It does not have to be another person. The law does not say you have to bring in another witness. I can bring in extrinsic evidence. That is the recording of him in the
She's getting defensive here.
interview room telling the police what he said.
All right. Mr. Short, I'm gonna admit or allow the state to play that particular portion from page 361, line 10 through 362,
You
line
lost this one.
10 as impeachment by contradiction. I'll give you a over defense objection. I'll give you a continuing objection as to that, sir.
Minus the,
Oh, of course, minus the 361 line 16, Shannon shot up that tour bus. That will be excluded.
what about?
Before you go on, can you give me the time reference, madam? Time, video and audio time.
So for the portion that is out is 3:29:37 to 3:29:39.
Okay. And the balance is from what time to what time, exclusive of those, at that time period?
So it'll start from 3:29:20 through 3:29. It will probably stop at 36 to make sure that we do not get into
Okay.
the middle part, and then it will pick back up again at 3:29:41.
All right. Mr. Short, anything, you were going to mention something else, sir?
And I understand your ruling as it applies. I respectfully disagree, do not waive any
Sure.
objections, but I understand what you're saying about he shot the gun and killed none. I don't understand how on the theory of impeachment by contradiction or prior inconsistent statement, how this part gets it. Thug, this is Kent Copeland. Man, whatever Thug say to these ends, Shannon will do it, man. Every time Thug say something, Shannon do it. Like now, if they want to get into the Bloody J thing again, I don't think he's denied anything with the Bloody J. I don't think he's testified to anything different about the Bloody J. He said Bloody J was beaten up. So I say that and beat him up. So those statements, I get what the state's arguing about the killed none. But those other statements, they're just bad character, generalizations, not inconsistent with anything he's testified to on the stand, not inconsistent with anything that he's been confronted with on the stand.
It's the respectfully, it's the conversation in the car that the jury decides whether or not they believe it or not, whether or not the version that they believe was the one that was done on the 10th of January of 2015, or on the stand on or about June the 10th of 2024. I think it's impeachment for what he didn't tell them in the car. Well, one, that he wasn't there, or two, what he said in the car. So I think that's what the impeachment's for.
But when he says, like, man, whatever Thug say to these ends, Shannon will do it, man. Every time Thug says something, Shannon do it. That's not anything that was discussed in a car.
State.
Your Honor, so two things as to relate to that portion. We have charged Mr. Williams with a leadership charge. So this directly goes to the fact that anything that the leader says, Shannon does. So that directly addresses the leadership charge that we have charged Mr. Williams with in this indictment. Furthermore, Your Honor, again, when Mr. Copeland has said everything that I told investigators regarding the night of the murder, regarding anything I told them. I was telling them anything to finesse my way out of going to jail. This would be in contradiction to it because he's saying that's a lie. Now, if the court would like, and I have no objection to asking him specifically, does Shannon do anything that Mr. Williams says, and then playing this portion, I have no objection to doing that. But it is important because we have charged Mr. Williams with the leadership gang count in this indictment.
Wow.
It's all speculation. And I understand that the state feels it's relevant because they've named that Mr. Williams, they've asserted that Mr. Williams is somehow a puppet master over everyone, which isn't true. But beyond that, just because they've asserted it doesn't mean all types of everything is admissible. It still has to be based on personal knowledge. It can't be speculation. And so, yes, they're asserting, okay, it's relevant because this is the way we charge the case, but that doesn't solve all the other evidentiary issues with. And again, we're not even talking about something that the man's saying on the stand. We're talking about it being played in a tape, out of court statements. So just because the state has indicted something a certain way doesn't mean they just get to play a bunch of tapes that fit their narrative.
Yes, sir. I'm still going to admit it for its purpose.
Wow.
Over your objection, I'll give you a continuing objection, sir, as to that respect.
Yes, Your Honor.
All right. We have one more, madam.
Yes, Your Honor. And that was for page 386, line 20.
386. Hold on one second. Let me see if I can find.
Look at this, from one sponsor to the other. I love our community, guys. Thanks again to Mike and Jazma.
Okay, you said 386?
Yes, Your Honor.
Line 2.
Page 387, line 12.
Okay.
And Your Honor, I believe this is Mr. Copeland was discussing the conversation that he had with Nutt prior to Kel. The discussion that Mr. Copeland had with Mr. Donovan Thomas Jr. regarding Mr. Copeland's differences with Shell Kel or Kelvin Watts, and the court wanted to know specifically if I had asked Mr. Copeland any questions about whether or not he had ever spoken to Nutt, and we were able to find in the transcript that I did ask him a specific question, and I can read that portion to the court.
All right, go ahead. What did you ask him?
So it starts with, do you recall telling Detective Thorpe that Nutt was somebody you could talk to? I don't know nothing about all that. Okay. Do you remember? I don't know. Yes, I said it to him. I don't know. Do you remember telling Detective Thorpe about the last conversation that you had with Nutt? I had a conversation with Nutt. Do you remember telling Detective Thorpe about a conversation that you had with Nutt? I don't remember what I told Detective Thorpe. Do you remember telling Detective Thorpe that when you saw Nutt, he just told you to chill out?
And guys, I'm going to rewind this because we just saw Attorney Sharp miss the mark with the last thing that he was trying to keep out. Now she is reading something else. And this is when Woody was on the stand in person, not in the interrogation video. This is when he went rogue, right? So what she's doing is she's reading the transcript from that day of what Lil Woody said on the stand. This is when he was being really unruly. I think it was 2 Thursdays ago. This might have been I think it was the day he was wearing white. and all those viral clips happen. This was Lil Woody saying, I don't remember what I told Detective Thorpe. And, I said what I said. I said what I said to get out of trouble. I said what I said. I don't remember if I lied. I don't recall. I don't know what you mean. All of those things. She is now rereading what Lil Woody said. So because of that, I'm going to rewind it just a tad because I want to go back to the beginning to see what part she's trying to show that he contradicted himself. I mean, all of it is a lie. Lil Woody was lying on the stand, but at the same time, was he lying when he was talking to detectives? He said he was going to finesse his way out of anything, right? He was sitting there in cuffs. So let's go back because I want to make sure that we catch up and capture everything that Lil Woody had said.
And just, do you remember find in the transcript that I did ask him a specific question, and I can read that portion of the court.
All right, go ahead. What did you ask him?
So it starts with, do you recall telling Detective Thorpe that Nut was somebody you could talk to? I don't know nothing about all that. Okay. Do you remember? I don't know. Yes, I said it to him. I don't know. Do you remember telling Detective Thorpe about the last conversation that you had with Nut? I had a conversation with Nut. Do you remember telling Detective Thorpe about a conversation that you had with Nut? I don't remember what I told Detective Thorpe. Do you remember telling Detective Thorpe that when you saw Nut, he just told you to chill out and then there was an objection by Mr. Steele. He said, hearsay. Court sustained the objection. I responded, it's going to be effect on the listener. It's going to be what his response was. Judge then overruled the objection. And then I asked him, that you told Nut, I'm just trying to get money. Was I supposed to say that to the police? Yes, I told the police. Excuse me. I said, you told the police. He says, yes, I said it. So that was your last conversation with Nut? I guess, yes, I don't know. When you say you don't know, what do you mean? I don't remember what I told any police. I don't remember what I have told them. And Your Honor, this portion right here, when he says, I don't remember what I told them, it really opens the door to all of his statements coming in without me going in line by line. However, the state has gone back, but the case that I cited to the court yesterday, which I think was the
Yes, Chris.
Scudder's case.
Scudder case.
In which once
Scaniers versus the state.
Scaniers
318 Georgia 855 decided April of 2024.
Yes, Your Honor. And once he says, I don't remember anything I told the police, I do not have to go line by line to asking specific questions.
Not saying you have to do that. But I don't think it gives you carte blanche, as I mentioned yesterday. So does your questioning again indicate questioning in regards to Kel or Mr. Stillwell?
This line of questioning discusses speaking to.
On the stand, let me be clear. From what Mr. Copeland was on the stand earlier, what did you ask him that on the stand when he was here several days ago that opens the door or allows you to play this particular part of the tape?
And this, it's not contained in this, what I have as a transcript, but I believe when I continued my questioning, I asked him specifically about talking to Kel. Now, I will take responsibility. I did not ask Ms. Weaver to give me the rest of this portion of the transcript, just solely the fact that
why don't I defer on it again until that'll be an outstanding one. You just need we will hold that.
Can I just clarify?
We'll hold that until the transcript is at least a little bit more readily available.
Can I clarify our stance, so?
I'm sorry?
Can I clarify our stance to kind of crystallize the issue?
In terms of what, sir?
Well, the state is asserting that they've established a foundation to get into either impeachment by contradiction or prior inconsistent statements.
Well, not yet, Mr. Sharp. I'm going to defer on that until I hear whether or not they have in fact asked enough for me to even entertain this particular part of the transcript.
That's what they're asserting. But just because they ask about
No. I agree with you. Okay, at this point. Well, I need to hear the statement first that was asked on the stand to make that determination. So that's why I'm saying let's defer it until that time, because I need to first hear what was asked, hear what his response allegedly was, and then determine whether or not it falls within an acceptable, if it does, exception for me to authorize them to play it.
Yes, sir.
Okay. All right. So just remind me, I'm going to hold that. Okay. All right. All right, counsels, is there anything else in respect to any of the interviews involving Mr. Copeland as it pertains to interviews on January the 28th, 2015, February the 21st of 2015, or June the 10th of 2015, other than the one I've held?
No, Your Honor, and the state's intention is to take the transcripts that we have, highlight the redacted portions, send that over to defense counsel so they can confirm.
I'm just going to say that you will be doing that the Thursday the 27th and Friday the 28th. Okay, because I do want to make sure you all have a chance to look at that. Please don't come here and we get Mr. Copeland back on the stand, and then you all want to still argue about redactions that. So I want to know if there are any problems before we put him back on the stand, or we resolve those. So yes, showing those. So defense counsel, is that acceptable to you?
Can I give it to them by Sunday? Only because, Your Honor, as the court may be aware, we have a full day of court with the other individuals on Friday. And so I'm going to work.
This Friday?
Yeah.
No, we're not.
No, not with the other.
Okay, yeah, that doesn't pertain to me. All right, so right now.
But it pertains to the members of the state.
One of my other colleagues. Okay, all right.
Yeah, so
okay.
we can have until this weekend. We do intend to get it to them by no later than Sunday.
At what time?
Sunday by 5.
My suggestion is that, and you all can do this the way you want to, but you all need to probably look at this. You know, you probably need to play it, yes, or at least the portions I've ruled upon. You all need to get together physically or have a representative get together and go ahead and make sure that the edits are correct. Because what I don't want to do is play things that are outside the bounds of what we talked about, and then there to be objections and problems. So can I get somebody's commitment to do that? And if so, when are you going to do that?
We can do that tomorrow, like just to sit through and run through the times, and we can do that. Right. And then the redaction, like with the actual transcript, I can get to get that.
All right. So defense counsels, are you okay with that suggestion? Well, who's gonna? All right.
Oh Lord, you're Steele.
Just generally, Mr. Steele. I know that you don't believe a foundation's been laid, and you believe that it is improper impeachment as a whole. So that is not lost, and that'll be your overarching objection, which I'm giving you and others a continuing objection for. But since I've ruled, to the extent that I've ruled on the parts that need to be omitted, that's what I'd like you all to at least make sure that occurs.
Yeah, as far as I'm concerned, Sunday is fine. That's what the state asked for.
Okay. Is that for the transcript, or are you all going to actually physically get together and look at the video and audio to make sure it matches?
Can I ask, is the state planning on taking the segments out so it jumps from one to the next, or is the state envisioning just turning the volume off?
We'll turn the volume off only because when we tried to convert it, and I think you all had the similar issue, it jumps. The video itself is not it's not good video. Unfortunately, when we try to convert the evidence reviewers to MP4s, it doesn't. It's not good video.
Okay.
To do that. So we can plan to play and stop. Now we can if defense counsel on their own wants to verify the times, and then we can verify the times, just make sure that the times are consistent. We can do that as well. If they would do that on their own and they can just forward us the times, we can do that as well. But we're open to whatever way to make sure that we don't have any issues.
Okay. And Mr. Steele, you said, or Ms. Sharp?
Speaking for myself and I think others, we don't know the technology involved, but we object to presenting it, just playing it and then turning off the volume for certain segments and then turning the volume back on. I think that invites the jurors to believe that something's being hidden from them, invites them to assume that it's
right, Nikki?
they're not getting evidence concerning our clients, and invites them to draw negative
We're a little behind
inferences
toast.
from that. So we would object to just turning off the volume and letting the video play. I'm not sure about the technological challenges. Someone that's smarter than me, I'm sure can find a way around that, but that's our stance.
Right, I think the court will instruct the jurors that they are only to consider admissible evidence. And so what the court has ruled or deems that portions are not admissible or that the state doesn't intend to play it. And there are portions that the state doesn't intend to play that defense counsel may or may not play. And so if we redact portions and make it seem as if there's one interview, the jury may get confused if there's a portion that the state redacted that now becomes a part of evidence when the defense decides to play portions if they choose to play it. And we've already been doing this in this method. This has not changed. It's nothing different than what we've already been doing.
Okay. Mr. Shard, I've noted your objection for the purposes of redaction. I'll just, at this point in time, given what we've done earlier and the challenges that we've had, we'll just turn the sound off at that particular period. And we'll do the best we can with that. All right, anything else? Okay, as it pertains to those 3 interviews. Okay, as Mr. Weinstein's got that look again, we're gonna go ahead and recess for a break and for lunch. Let's come back, councils, at about, let's just say 1:15, and we can go ahead at that point in time and take up the jail calls that Ms. Hilton has, we'll identify the email, take up the jail calls that she plans or that the state plans to play at this point in time. And we'll see where the day leads us at that point, okay? All right, I'll see y'all at 1:15, all right? We're in recess.
All right, guys. So they are in recess. They got a lot done. This is good. This is very good. What did they get done? And let me just recap all of you guys that have come in, and thank you all for the support. There's so many of you guys supporting the stream. It's unreal. It really is. And, it's nice to see that the public is really interested in this trial. And again, I apologize, guys. I'm by a window by the ocean, and you can hear some birds. So it might sound like I'm in the middle of nowhere, but what we'll do is I'm going to recap you, let you know where we are. The court is in recess, so they should be back in about a half hour. I'm going to read all of these super chats, all of the cash apps, and get us back up to speed. So a few things. We saw them get through all 3 of the interrogation videos finally. It took us 3 days, right? So they got through all of the videos on Monday, Tuesday, Wednesday, like all of last week. They've been going through this interrogation footage. Why? Because Lil Woody went rogue on the stand. We haven't been able to believe anything that he's been saying. He contradicted himself. And so the state had no choice but to go back to the footage. So we've gotten through those 3 pieces of footage. One was from January of 2015. One was from February of 2015. And we just finished the one that's in June. For the rest of the afternoon, when they come back, we are now going to focus on the jail phone calls. I'll be honest, guys, I'm looking forward to those jail phone calls because hopefully the prison system, the jail, probably has better audio that we can hear. Okay. These interviews were very hard to hear because we could not understand what Lil Woody or the detective was saying. I think it was on Monday. The judge had to play something back like 6 times just to hear what Lil Woody was saying. Right. So they've gotten through all 3 of those. I believe there are about 9 jail phone calls. It should be relatively quick because they're about 15 minutes long. So we're going to, do that for the afternoon. So don't go anywhere. Get your snacks and your popcorn. We're going to be spending the afternoon together. That'll be really fun. So now that we've done that, the other big update I have for you guys, a lot of you have been asking about yesterday's hearing. What happened to Kayla? What happened to Miss Bumpus? What's going on over there, right? Well, the other thing that's been going on is the judge, he had postponed that hearing. So it was originally scheduled for June 25th. It has been postponed and rescheduled for July 3rd. So next, next Wednesday, a week from today, we will have that hearing, okay? And it's right before the jury comes back. They're coming back after the 4th of July. Woody is coming back after the 4th of July, maybe sooner if we get through all this stuff. But that hearing has been postponed until July 3rd. Now, also happening on July 1st, Monday. So we'll see what time they set up in court on Monday. But on Monday, we are going to have the defense attorneys finally have access to the transcript from the secret meeting. Now, keep in mind, Judge Glanville redacted it. So they're not going to be able to see every single word that took place in the secret meeting. They're only going to see portions of it. And it's going to include Brady material, Brady evidence. What is Brady evidence? It's evidence that can exonerate the defendants. An example of that meaning Lil Woody in the room, in that secret meeting, in the ex parte meeting, claimed to have killed Donovan Thomas, aka Nut. He busted Nut. He busted at Nut, right? So that's an example. But who does that help? That helps Young Thug. It helps Shannon Stillwell, because Shannon is allegedly, Lil Woody said in one of those interrogation videos that it was Shannon that killed Nut, right? And that Young Thug ordered Shannon to kill Nut. So this is going to impact a few of the defendants if Lil Woody was in that secret meeting saying that. And the defense attorneys have been fighting to get their hands on this for weeks. Why did Judge Glanville finally make the transcript available? Well, that's because a writ of mandamus from Mr. Weinstein was submitted to the Georgia Supreme Court last Thursday. And I'm going to show you guys this because I've been showing it to you almost every day. I'm checking. I go to the Georgia Supreme Court website, the Supreme Court of Georgia. I go to their docket system, and I'm going to refresh to make sure nothing has happened, but I check it out. I see where we are, and you guys all have access to this. If you want to search by case number, you could do that. I search by party names, and look at that. We type in Glanville, right? We could see the status of the case. So here's the case right here. It's still in, the case status is docketed. All right. So Diamante Kendrick versus Ural Glanville. Okay. So it is docketed, meaning that they have it in their system as of last Thursday at 3 p.m. Okay. It was filed around that time. If you go to judgments, this is where you'll see any updates for the case. We don't see anything there. And then aside from that, you just see the attorney information. So we are patiently waiting for the Supreme Court to come back with a decision on what they're going to do with Judge Glanville. Are they going to order Judge Glanville to recuse himself from this case? If you guys, I think it was 2 streams ago, there was a very, very tenured attorney, Attorney Tate, who is an esteemed attorney in the state of Georgia. He wrote an affidavit in support that Judge Glanville hasn't been acting appropriately in this case, making decisions that aren't the best. That whole secret meeting was not okay. And they're looking at his conduct, not his rulings, his conduct. I did a full breakdown on that. And I want to thank you guys for sending me some information on it as well. And we were able to look at how all of this made sense. So we don't have a decision yet. I saw a few of you guys asking why Judge Glanville is still presiding over this case. Until we hear back from the Supreme Court, we won't know. The other thing is, the Supreme Court in Georgia seems to move fast. They had a pending issue with Christina Peterson. I'm not going to get into all that. I made a statement a little bit earlier on the Peterson matter, but they had just come back yesterday with their decision on Peterson. And I think that had more to do with her, some of her rulings as a judge and some of her conduct as a judge, not particularly the body cam footage that had come out last week. So that's a whole nother ball game that I'm not getting into. But they have been moving pretty quickly. We saw them move pretty quickly with Brian Steele, right? Brian Steele is not in jail every weekend up until August because the Supreme Court moved within 48 hours to grant him bond and reverse the decision. Not reverse, but at least stop Judge Glanville from putting him in jail. Okay, so we have that going on as well. All right, guys, let's read a few supers, hang out for a little bit. We've got a few more minutes. The court is supposed to be back at, they are supposed to come back at 1:15. I'm just going to keep popping in on the feed, and we've got some TiVo time. I was about 10 minutes behind, so I'm just going to scroll us up. Now we are live, so as soon as they come back, I will bring us back to the feed, and we will go from there. Huge, huge, huge shout out to Mike in Tennessee. Huge shout out to Jazma. One thing you guys don't know is I actually have a website. It's called av7digital.com, and I do offer consultations when I have some time. But what I do is if anybody's an aspiring creator and you want advice, and mostly for our female live streamers, if there are any women that just want to chop it up and learn about YouTube and learn about how this all works, I'm more than happy to spend that time with you. If there are any aspiring law students, I have a consultation just for law students, and I share a lot of study tips and things that got me through law school. You guys know right now I'm in the process of getting ready for the bar exam. So if there's any law students out there, and of course it's not expensive at all, but I do offer those too. And then, a lot of people don't know this about me, but I spent 15 years in corporate America, most recently as a communications manager for one of the nation's largest banks. And I worked for the chief legal officer. I used to get them ready for Capitol Hill, like all of those things. Your girl has some corporate chops. So if you wanted general business advice, you could check me out on my website. So, whether you're a business person, whether you want YouTube advice or law school advice, check me out on my website. But I say all that to say, Jazma and I are meeting next week to chat. So I'm really excited to meet with her. So if any of you guys were looking for that information, that's what you got. So thank you, Jazma, for being our stream sponsor. Mike in Tennessee. Let's go all the way to the top. Shout out to Mama, who became a YouTube member. Thank you so much, Mama. You're going to love this community. I'm hiring people to help me with all of this stuff. But really, I want to start giving the members perks, not just to have chat privileges, but I really I'm starting to want to give you guys extra content. I used to do a lot of polls where I would just poll my membership, base. What do you guys want to see next? Give you an opportunity to talk to each other. Building out a Discord. A lot of you guys find legal documents for us. A lot of you guys find, clips floating around on the internet, and you're like, hey, check this out. We want to start creating a community for folks like that and providing some perks for members. So thank you so much for becoming a member. And speaking of members, shout out to Real Talk with Retta, who has been one of my longest running members for 13 months. She says, so proud of your continued success. Thank you so much, Retta. She has been rocking with me since the beginning, guys. Like from day one when I got monetized on YouTube till today. I appreciate you so much, sis. You have no idea. Shout out to Yami, who says, good morning. Good morning to you, Yami. Yami, I like your name. And is that, that's that cartoon character. I forgot what cartoon that is. It's on the tip of my mind. I can't remember off the top of my head, but I recognize it. Thank you so much, Yami. Shout out to D, who is in here with $4.99. He says, do you think the writ of mandamus triggered the reschedule by Judge Glanville? D, that's a good question. No one knows what the reason behind the rescheduling was. You guys saw me and Lead Attorney. We interviewed Kayla on Monday. Kayla Bumpus came to the show on Monday. She was in town expecting to go to the hearing on Tuesday. Last week, we talked to Sylvia, a woman that has been going into the courthouse for 2 years, right? And we had an opportunity to talk to Sylvia. Sylvia, when we talked to her Thursday night, she I don't know where her source is or where the information's coming from. Sylvia said that she didn't think that Tuesday was going to happen. I wonder why. I wonder what that basis comes from. And, there are several questions that come to mind, right? I don't know why, but I do think that the writ of mandamus did trigger something because guess what, D? In addition to that rescheduling, they got their transcript. They got their transcript. Isn't that funny? The transcript all of a sudden is ready. All of a sudden ready by Monday, so that's interesting. Great question, D. Thank you so much. Shout out to Ray with the $5. Thank you so much, Ray. He says the one constant at government functions, you have to wait on them. They get paid on time or not. Yeah, I think this was around the time where we know that Judge Glanville presides over court very, very late. He's not on time. He wasn't here at 10 o'clock like, hello, court is in session. He was not. I think they started about like 35 minutes late. We were all waiting 35 minutes late. And that's been happening a lot. The secret meeting took place. Court was supposed to start that Monday at like 9 a.m. It didn't start until 11:30. I'm happy we're not getting sessions like that anymore. But yeah, they've been pretty late. But thank you so much, Raymond, for that observation and for the super. Shout out to D, who's back. He says, I can't, with 199, he says, I can't see AB7 doing battle in court. I do have a really nice side to me, guys. But yeah, when it comes to court, I actually did this in law school. Here's a quick story. In law school, they have, we call it trial team. It's like moot court. And it's like, it's like, I like to describe it as sports for nerds, right? It's intellectual sports for nerds. We used to go up against other law schools and, argue fictitious cases. So my school, we were in Massachusetts. So we did the Aaron Hernandez case, right? I was on the prosecution side and, my partner, oh my God, y'all are going to love this story. I had a day student as my co-counsel, and he was, this is going to sound bad. He was a really nerdy kid. I call him a kid. He was a lot younger than me. Now he's actually a prosecutor these days. I think he passed the bar exam and now he's a prosecutor. I hope he doesn't see this. But this kid was so nervous. Like we practiced. I was just like, here's the questions. Here's what we're going to ask our witness on the stand. Let's practice our opening argument. Let's practice our closing argument. Like I think I did the closing and he did the opening, but he was so nervous as a public speaker in front of other people. I kid you not. He would stand up to do the opening and he couldn't get past it. It was only like a minute and a half of things he needed to remember. And the judges in the case were not going to get mad at you if you forgot your lines. Only you know your lines, right? He was a Hispanic, super fair. You guys always make fun of me that I'm like really light skinned. This kid is like transparent, okay? Super transparent. And he got beat red. Like he would start sweating. He was sweating profusely. And I'll be honest, it's going to sound bad, guys, because I'm making fun of her. But I was like Miss Love with the Post-its. Like I was writing down what he should say. I'm like, don't forget this. Object to this. Like just on top of him. And like, that's why I'm watching this. And I'm like, oh, I know what that's like. Or I know what it's like to be that person. But sometimes you got to let people do their thing. You got to let them learn. So, we learned trial presentation in law school, like on teams like that. And it could be hard. Like, one time I think we made it to like round 2. So we had to go up against another law school and they were good. Like they were from the South. I forget which state they were from. It might've been Georgia, actually. It was another Georgia school and they were really good. They were very well prepared. And there was this other guy, he was probably in his late 20s and he was on the defense side. He did a great job, did a super great job. But same thing. They had a difficult witness on the stand. He started sweating. To the point where he's like, can I have some water? He almost passed out. I was like, damn, they're getting us ready early. So those were good times. But shout out to that kid. He is now a prosecutor here in Massachusetts. I forget which district he's in. But it was so funny because I saw him when he was like, nervous as hell, and now he does this for a living every day. Isn't that crazy? Anyway, long-winded story, but thank you so much, D, for the super. I appreciate you. Shout out to V, who becomes a YouTube member. Like I said, there are perks coming for you. So thank you so much for becoming a member, V. Welcome to the community. You're going to love it here. Shout out to Sean Miller. He's like the only other person I know from the lead attorney space that's been around just as long as me. Like I've been hanging out in lead space for almost 3 years now. But Sean, I remember you. Sean's from Boston. He's from up here. I saw you guys chatting about the parade and how crazy people were. I was streaming that day. Luckily, I wasn't in that part of the city, but that was 2 streams ago when I was in the little phone booth. That was the day of the parade. So I hope you got a chance to celebrate, Sean. But Sean says, prosecutor, what time is it? Lil Woody, what you mean by time? Time is relative. Thank you so much, Sean. That was super funny. And thank you so much for the super. I appreciate you. Shout out to Vita with the $2 and says, good morning, AV. Let's get those likes up. Thank you guys for the likes. You've been fantastic over here on my little tiny channel. Look at that. We're almost at 34,000 subs. So if you guys sub today and just found me today, welcome. And Vita, thank you so much for the reminder on the likes. I appreciate the cash, the super chat. Shout out to Maria, who became a member. Maria, welcome. Like I said, perks are coming. Perks are coming. And look at Emerson. Emerson has become a member too. Welcome. Welcome to you. Shout out to Orlando with the $4.99. Orlando says, how do they have these transcripts, but not the one for the ex parte meeting? Exactly, Orlando. We just looked at transcripts that were like 400 pages long of 3 of Lil Woody's interrogation sessions. 400 pages long, guys. It was like a novel. It was a novel, right? So, we have all of that going on, but we couldn't get the transcript from the ex parte meeting because Judge Glanville is protecting something. I'm telling you guys, he's protecting something. If they had to redact it, they needed to protect something, right? So the only people that know what happened in that meeting are the people that were in the meeting. We were trying to pull it out of Caleb Bumpus the other day. Lead was, at least. He was just like, tell me, give us the tea. But she can't say because, she's just hired her own legal team. She's got 5 attorneys representing her. She can't really tell us what happened until after this matter is closed. She has agreed to come back on the show next week. So after the 3rd, she's maybe we can get her on the 3rd. But, if we could get her on after the 4th of July, that Friday, I think that would be fantastic because we'll finally get information on the secret meeting and what took place, right? Because this contempt hearing should be interesting. So thank you so much, Orlando. And thank you so much for the question. Shout out to Tiff. Tiff has become a new member. Welcome, Tiff. It's good to see you on my side. And then shout out to Audrey, one of my day ones. Well, not even a day one. You've been around. You've been around for some time, but I appreciate Audrey because, whatever y'all contribute, I don't care about amounts. I really don't. But Audrey will bless me every single time I'm over here, every single time I'm on lead side. She's super active in the comments. I love that encouragement. So Audrey, thank you so much. And, she's been a member for 2 months. I appreciate you, sis. I hope you're having a great day. Janelle, I flag this from time to time. If you guys have a good question, I will flag it as we go. Janelle says, AV, maybe you can answer this question when the court takes a break. Is it true that the jury will not be paid until the end of the trial? That's not true. I think that they're currently being paid right now. Sylvia may have answered this question last week. We had a pretty interesting discussion with her about the jury members. She had special names for them. I think she called one of them Nose and Ryder, and because their names can't be disclosed. A few of the women be sitting there looking at Adams in the corner, little sharp gentleman in the suit, they're like, okay, she believes that Ryder has a crush on Adams. She's always paying attention and smiling, things like that. The jury thought that Lil Woody was funny. But she did say that their ages range from 23 to about 65. And they are being paid. It's not a lot of money. We talked about what it was like $25 an hour or $25 a day. I don't know if that's the actual amount, but it is something a lot lower than what they typically get. Right. So, if you have a job and you're a teacher and you get paid $25 an hour and you're on this case for damn near 2 years, It's not very fun. But how can the state or how can the judicial system do that to the everyday American if you are forced to be on jury duty? You can't like take someone's livelihood away for 2 years. That would be terrible. So they are being paid. Thank you so much, Janelle. Shout out to Question Everything with the $2. He says, Hope Nut got that hooked before he passed. Have y'all seen this? And shout out to Drew Beats. Someone sent it to me on Instagram. I saw the clip over these past few days. It's like this it's this white woman, and she was talking about, I don't know, like, you got to spit on that thing. You can use your imagination of what she was talking about, but that has gone viral all over the internet over the past few days. Let me check it out here. It looks like they are not back yet. It's 1:06 right now. They're due back at 1:15. Hopefully they're on time today, but one never knows, right? Shout out to the blind man with $2. He says, nothing better in the morning than AV. Okay, thank you so much. Thank you. I'm happy to be here in the mornings, right? I'm happy to be here. I'm actually way more productive in the morning than at night. You guys see me on the other side. Like it'll be 7, 8 o'clock at night, and I'm almost out. I'm almost out, bombed out and depleted. Shout out to Wyoming Gal. Thank you so much with the $2. She says, thank you for showing this. I subscribed. Welcome, Wyoming Gal. You'll like it. You will really like it here. I'm pretty sure you're going to have a great time. Community is amazing. They are jokesters, so you'll have a great time in the chat. But welcome. I'm happy you found me today. Raymond is back with another 5. Raymond, he says, I might live in isolation. And if it wasn't for AV, I wouldn't know who the hell Thug is. Just another street corner. Well, I mean, that's the thing. You guys, we cover different trials. We've been covering this YSL trial. I have been watching a few things over the past few months. We have been watching the whole Fonnie Willis thing because at the time I was living in Fulton County when Lead and I were covering that. So I was really, really close and interested in it as a taxpayer just to see what was going on down there. But I like hip hop cases too, guys. Keefe D. Keefe D is the gentleman that's on trial right now for the murder of Tupac Shakur, right? Just arrested last year. I couldn't believe that they had just got this guy like over 30 years after the murder of Tupac Shakur. The Shakur family is not very, they're not very confident that that's going to result in anything because the strongest evidence that they have on Keefe D is this, right? They have him on Vlad TV. So like literally the YouTube channel, Vlad TV. Keefe D would do interviews and he would talk about the murder of Tupac Shakur. Because he really wasn't the shooter. I think his nephew, Orlando Anderson, was, right? So you have that. So Orlando was the actual shooter. There was like other people in the car. Keefe D was in the vehicle, but he would go on Vlad TV and just talk about the murder freely and nobody did anything, right? They raided his house last summer. I think it was in July, and they found shell casings from the scene of the crime. I don't know why Keefe D would keep it, but the shell casings that matched up to the murder, right? Keefe D, he had that. He even wrote a book called Compton Street Legends, where he profited off of Tupac's death. He talked about it, sold a book, talked about his experience. I kid you not, right? And really, the moral of the story with him is he's told on himself. He was running around the internet telling on himself. So Keefe D got picked up. They raided his home, and he got arrested in September. He's been sitting in jail up until recently. There was a bail hearing yesterday. I haven't watched it yet, but maybe I could do a short video on you guys for those that are interested in that one. I've been covering Courtney Clenny, that woman that stabbed. She threw a knife from across the room. White woman. She killed her black boyfriend. Her parents are so freaking entitled. They're rich and tried to cover it up. They were deleting evidence from the guy's laptop after he passed. His family's pissed. But yeah, I've been covering that one too. But lately we've just been sticking to the YSL trial. So there's more content to come, Raymond, but I'm glad that you enjoyed this one. Again, Mike in 10, thank you so much. You have no idea how much that super meant to me. Thank you, Mike. And then shout out to Band Up Gang with $4.99 who says, one thing we all learned is don't have Miss Love on your case. She's going to D-ride. She is. She's just going to watch you, pass you Post-its. You know, like you can't even like she'll sometimes. Here's the thing about Simone Hilton. Half the time, Simone will be in the middle of a thought or a sentence or be talking, and then Miss Love is like, "Hey, don't forget to say this," or "Hey, don't forget to say that." It's just like, girl, let her think, let her process. You know, appreciate the help. But right, you know, I would rather get a post-it than somebody in my ear while I'm speaking. You know, so again, as someone that's done that, I'm much more prefer the post-it approach than the let me whisper in your ear like, hey, don't forget to say this, or hey, don't forget to say that. Like it's just like, all right, like the whole courtroom can hear you. That's not a whisper. That is not a whisper. You know, so too funny. Jazma, thanks again. Looking forward to talking to you next week. Thank you, Jazma. Lovely Baby became a member. I love your picture. Thank you so much, Lovely Baby. You're gonna love it here. Welcome, welcome, welcome. And then shout out to Terica with the 50. Guys, check out Terica. She has a channel. It's called The One Lo-Fi 2. She is extremely generous. She is a great supporter of both me and the lead attorney. Every time I'm live, sometimes when I just drop videos, she's in my chat, she's supporting, she's such a great sister, super funny. I think it was like last week or the week before. Yeah, it was last week. She made an animated, like almost like a Pixar photo of me and lead. It was hilarious. And like I looked like a little kid with some bangs and some glasses, and he looked like 30 years younger. It was hilarious. So check out Terica. If any of the mods can find her channel, drop the link in the chat. She does lo-fi beats. So if you are folding laundry, cleaning the house, sweeping, you know, whatever you're doing, and you just want to listen to some really good music, she puts videos out all the time and is always live. And some of those videos are super long. So they're like 2 or 3 hours. Even if you're working out, you're on the treadmill, you're not listening to me or lead, and you just want to listen to some music, check out Terica's channel. She is a gem. Thank you so much, Terica, for that one. Shout out to Tyler Barbary with $10. He says, he or she, because sometimes I'll say things like names like Ricky from yesterday. She's like, I'm a girl. I was like, oh my God, I'm so sorry. Well, shout out to Tyler. Tyler says, appreciate your coverage. You're the best. Thank you, Tyler. Thank you. Thank you. I really appreciate that. Shout out to Demelise, who has become a member. You're gonna love it here. Demelise, welcome. Shout out to Spit and Fire with the $50. Who says support, good work, AB. Spit and Fire, same thing, super generous. You guys don't have to do it. It doesn't matter what amount that you support the channel with. I really love what I do, and I love being here with y'all. In fact, I want to also say welcome to all the new subscribers, because we just crossed 34,000 subs. So thank you guys and welcome. You're going to love it here. Spit and Fire, thank you. Super generous. Again, you don't have to do it, but I'm just grateful to have such a good community where y'all just support. You see the time and effort that goes into this stuff, and you're here supporting. So thank you for that one. Shout out to Miss Crow T Shetty, who at $20, she drops a super sticker. It's so funny, Miss Crow T Shetty. A few months ago, Lead and I forgot where we were, but we saw something on like a flat screen TV, like a TV, and it was a reality show. I think it was, y'all know that it's like a game show on Netflix, Squid Games, but the reality TV version. And there was this very strange man that wore like this netted, I think he's from Alternative Lifestyle. I think he was gay. No shade with that. But he had like a crocheted dress on and like a crocheted hat. And we saw it. I was like, Lead, shout out to Miss Crow T Shetty. It was hilarious. We were crying, laughing. So I've been dying to tell you that story, Miss Crow T Shetty, but it just reminded me of that. So I wanted to tell you. Shout out to George Collins with the $1.99. Thank you so much, George. Thank you. Thank you. Shout out to Noble with $2. He says, Judge says 30 minutes expect to be back in 50. Where are they? Where are we with the feed? Where are we? They're not back. We're up to date. We have 1 minute till showtime, but I doubt it. Sometimes they come back on time. Sometimes they don't. I think they were late yesterday. Not too late when they came back from lunch, but who knows with this group. Let's see when the judge comes back. And you guys noticed that dog had not gone out for the whole morning. Like since we started at 10:35 until we broke around 12:40, that dog was sitting there for 2 hours. So they're going to take a comfort break and a lunch break. So thank you so much, Noble. Shout out to Spittin' Five, back again with the $5. And it says, wait, Woody bust a nut? AV, that doesn't sound right. Well, the victim's name was Nut, okay? And Woody, right? Woody saying that he shot Nut. He killed Nut. It came out wrong. That's what she said. Thank you so much, Spittin' Fire. Shout out to Till with the $2 and says he busted Nut. We need a pause for that, AV. It's that or scrambling and scraping. We're grown over here, right? We're grown. Shout out to Jay Wash, who says busted at Nut or on. Okay, all right, y'all are getting this. The guys are getting a little frisky. All right, you're getting frisky on this Wednesday. That's what she said. Shout out to the Haven, who has become a YouTube member. Welcome, Haven. You're gonna love it here. I know you will. I know you will. Thank you so much for becoming a member of the channel. Shout out to Ashley Kane with $19.99. Ashley says, thanks for this. I work with hospice patients all day. Wow. Thank you for keeping my mind busy, listening to the court cases. I love the law. Always been such a passion. That is so cool. And honestly, Ashley, you have a pretty tough job. But at the same time, I know it goes by slow. And, you know, like it's one of those things where if we can entertain you and bring you some joy throughout the day, have you smile throughout the day, laugh a little bit and talk about some of these court cases and the shenanigans that have been happening in Fulton County, the shenanigans that have been happening in this trial. And I'm sure Woody made you laugh a little bit too with a, what you mean, right? So I'm glad that we can bring some joy to your day. Thank you so much for the super. And thank you for letting me know. I love learning more about you guys because it definitely helps me shout you out more and appreciate you. Appreciate you guys as well. Shout out to For Always, Forever, For Life. You always strip me and lead up when we read it on his side, but I'm happy to see you over here, sis. She has become a member. Welcome. You're going to love it here. Uh-oh, here we go. For FFS, which means, and I'm going to swear for the faint of heart, for fuck's sake, has dropped $1.99 and says, good afternoon, sunshine. You know what used to get me? He got me on Friday because he was dropping a ton of supers and I had to say that. And it was kind of like, I was struggling. I was like, FFS, you know, because it sounds similar, right? So thank you so much and good afternoon to you as well. Shout out to Configure Plus, who's become a member. Welcome, Configure. Welcome, welcome. Let me peek in on the feed, guys, and see where we are. And again, apologies for the birds. Yeah, they're not back yet. It's 1:17, so I'll keep peeking in. And I am almost caught up on super, so we'll go to the Cash App side in a second. Shout out to, here he is again, FFS with $1.99. He says, don't care about amounts, proceeds to wear a 300K hat. For fuck's sake, come on. I forgot about that. Yes, that this is that he's referring to a capping moment that I had with Lead when I first started co-hosting, and you know what? Maybe I will clip that up and put it on Instagram later so you guys get the reference. But some of you were there, some of you weren't. I will definitely put the reference on IG later because that is hilarious. Shout out to the one Lo-Fi. Look at you, Terica, back with the 10. She says, AV, is it normal or typical that the first couple of court dates can be expected to be rescheduled? Yes, that actually is quite normal. It has happened to so many cases. It's happened to cases that I've been covering here on this channel. Courtney Clenny, for an example, she was supposed to be tried last year. Her trial has not started yet. And that's because there's a lot of pretrial motions, a lot of pretrial hearings, kind of like what, not like what we're watching right now, but this should have been done pretrial. It's hard to say that, though, because no one could have predicted that Lil Woody was going to be this difficult on the stand. So they actually had to make a decision and do this spot on, like right away in the moment and go from there, right? So it's been a difficult one, but it is typical. We saw that with Courtney Clenny. It happens with federal cases, too. You'll get court dates rescheduled, moved, things of the like. I don't know why Judge Glanville moved yesterday's hearing. I'd be super curious to know what the reason was. Because he ordered everyone to show up no matter what. And, you know, poor Kayla flying in from Texas, like now she has to go back. So super, super crazy. All right. Shout out to Mixed Chick Samantha. Thank you so much with $4.99. She says, have you looked at Thugger Daly's last post? Ooh, I love when y'all bring us the tea. Let me go to Twitter All right, guys, who is Thugger Daily? Thugger Daily is, I believe, a blogger. He has been covering this thing like nobody's business. And he is very, very fast with getting us information. He has posted something 19 minutes ago, and it says this Friday is a day off. So we know that, guys, that, you know, there's not going to be any court, I believe, tomorrow and Friday. So we know that the YSL defendants are waiting for the trial, and they will be in Judge Alfred Dumpsey's courtroom for a status hearing on motions. It's expected to take the full day. Okay. And they don't know if it's going to be streamed. All right. He posted 30 minutes ago. He says they just finished the last of the redactions. So we know that the state will be playing the full footage and just turning down the volume and pausing it when it gets admissible in portions. What that basically means is when Lil Woody comes back, they're going to ask Lil Woody questions. If he's difficult, they're just going to play the video. They're just going to play the video. We're not playing games with you anymore, Woody. Like, did you say this? Huh? What you mean? I don't recall. None of that. Like, they're going to play the video. So now that that's ready, we're good to go. He also says the defense objects to this method of presentation, arguing that it would cause jurors to feel like the facts are being hidden from them, which is overruled. The presentation when Woody comes back is going to be super tedious with lots of starts and stops. Yeah, it's going to be difficult, and I'm sure he's going to get annoyed when he's back on the stand. And then another post from Thugger Daily 37 minutes ago. It says finishing up the redactions for Woody interrogation footage. Yeah, I think we're all caught up. So Mixed Chip, unless I'm missing something, just let me know. But it looks like we're all caught up there. Okay, yeah, I'm all caught up on his feed. But thank you so much, Mixed Chick Samantha. You are the best. Shout out to Anna P. It's good to see you on my side, Anna. She drops $19.99. She says, finally caught alive on your channel and can super chat. You're awesome, and your takes are always insightful. Any idea on when and if the Supreme Court is going to issue an order? So again, guys, I checked the dockets for you. Let me see if I can share a screen, share this tab instead. I've been refreshing throughout the day. But yeah, I check their system for updates about once a day, just to make sure that we are up to date. And you guys have access to this too. It's the Supreme Court of Georgia, case information, go to the docket system, and then I look at the case status. It's docketed, which means that it's just been entered into the system. Nothing has happened there. I'm just going to refresh and search by party names. We're going to Glanville. There is the case. And yeah, the case status as of right now is still docketed. So I'm guessing that we will hear back from them hopefully this week, but it's hard to say because, the Christina, the other judge, that issue took a little while before we got an answer back. So it's hard to say, Anna, but hopefully this week. If not, I would say it would have made sense to get a decision prior to July 1st and prior to July 3rd. Because the contempt hearing is on the 3rd and the transcripts are going to be made available to the defense team on the 1st. So it would be amazing to get something back Thursday and Friday since these guys are not going to be in court anyway. So I hope that answers the question. Thank you so much. Shout out to Michelle, who's another one of my faves. That was cute. She drops $2 and says, don't forget to grab some lunch, AV, and all. Of course, guys, definitely going to duck out. And again, I think today is supposed to be a shorter day for the court. If I need to run over to grab something to eat, then I will definitely do that, or order something in and just, again, it's probably rude to eat in front of you guys, but keep it on mute and just chomp as they are working on everything in court. So I will definitely do that. Thank you so much for the reminder, because your girl, sometimes I'll go hard and just work and not eat, and that is not healthy. So I will definitely make sure that I do that. Thank you for the reminder, Michelle. All right, guys, it is 1:24. Of course, they're late. They're not back yet. So I'll keep poking my head in just to see when they start the feed again. Shout out to Configure Plus with the $2. Thank you. Who says love the content and the coverage. Thank you. I love you back. I'm glad you like it. And, I'm happy that I can provide some color to you guys and explain what the stuff means. Shout out to Army Nurse with $2 and says for the love. Thank you so much, Army Nurse. And if you have served our nation and you indeed are a nurse, thank you for your service. Really, really appreciate that. My girl Janelle has become a member. You already know, Janelle. Thank you. You are another fave in the community. Thanks for the membership. Welcome. But you don't need a welcome. You've been around for some time. Terica is back again. Terica, I think you're in for 80 now. She says, thank you for the shout out. I appreciate you, sis, and lead so much. I will have to create a special AV lo-fi playlist. Please let me know what kind of genre you would like. Oh, I do like lo-fi. I like lo-fi hip hop, but like what do you call it? Electronica. Like Cascade is like one of my favorite like artists. Like when I'm busy and doing stuff, that's what I listen to. All right, guys, we got a little bit of movement in the courtroom. I saw a head. I saw some people walking by, so I'll keep my head in on that one. And Terica, thanks again. She's made me a playlist before, guys. She's made me a playlist when I was driving. I had a really long drive recently, and she made a special playlist for driving. So all our truckers out there, check her out. Check her out for sure. Question Everything became a member. Thank you, Question Everything. Look at you. Look at you becoming a member over here. All right. Let me go to Cash Apps because I have not read any of those. Real Talk with Retta has sent me a $5 Cash App. She says, keep up the great work. Your numbers are rising. They are. They are. You put in the work and hard work pays off. That's what happens. So thank you so much, Retta. I appreciate you. Shout out to Candy Yates, another one of my faves. Candy with $20. Candy says, for hey AV, great coverage as always, sis. I appreciate you. Like I said, guys, like being a content creator is not easy. People say crazy things, but when you get love like this, it just makes you want to keep going and keep doing it. So thank you for that one. Shout out to Ricky, who sends me $5. Thank you so much, Ricky. No comment, no question. Pure love of the game. That was really, really sweet of you. Shout out to Denise D with $5. She sends me a link. Denise, during when they come back, I'll check this out and see what I can find from it. We always, with YouTube links, we have to be careful because if we play music, they can demonetize a full video. So I will check this out, and thank you so much. And yeah, whenever you have links, you can send me an email. You know, that was really sweet of you to send a Cash App, but I'll check it out. Thank you. Shout out to Freddie. Freddie, are you on my side, Fred? He says, he sends $5. He says, that dog only barks when it hears some bullshit. It really does. I think he's talking about Judge Glanville's dog, the support dog, the service dog. The judge has a service dog in the courtroom. You can hear it, like, you can hear the dog shaking from time to time. You'll hear his little collar, like we'll hear the dog. In fact, the dog, I believe, has been in the chat with you guys. We have our first troll over here. So I really enjoy seeing the dog in the chat. That is hilarious. Thank you so much, Freddie, for the Cash App. Shout out to G Doves. Hey, G Doves. She's on my side too over here. Sends $5. She says, enjoy your streams, coworker. LOL. Yeah, listen. I love, being on the stream and hanging out with you guys throughout the day. It's really a lot of fun. So I'm happy that you like it. Shout out to Liz. Liz is on my side today with $1. It says, I cannot wait to the closing arguments. Can you guys imagine? Brian Steele is going to go in. I actually really enjoy when Brian Steele, because he's kind of on the shorter side. When Brian Steele starts yelling a little bit, when he turns up, I'm always like, oh, what is Brian about to say? What is Brian about to say? I can't wait. So I'm looking forward to that too, Liz. That should be really, really good. Shout out to E. Capone with the 5 who says, keep talking that law, AV. Yeah, no, I enjoy it. I love this stuff so much. You guys have no idea. To be able to do this from home and chill and study, like literally, like my mind is in trends with justice. Like all the time. It's crazy. Shout out to Drew Beats with the $4. He says, if you are a jury, would you sneak and watch news? Ooh, you're not supposed to do it, but how can you avoid it? People were saying that Miss Sylvia live streams from the courtroom. From the courtroom. I hope she has permission for that. But like, how do you avoid it? Like there's cameras everywhere, it's been going on for so long. What if you accidentally click on something? You can't go to social media. Can you even use social media? It's everywhere. Lil Woody went viral. I was looking at his Instagram this morning. He now has like 83,000 followers. And when he started the thing, he had like, a lot less than that. I think it was somewhere around like 15,000. So in like the last week, he's blown up. And those are viral clips. How do you avoid it? Law and Crime has damn near a compilation on all of his funny moments. Like it's interesting. If I were on the jury, knowing me, I like to do the right thing. I probably wouldn't do it, but I think that I would stumble upon it accidentally. But like, can you look away? Can you look away? I'm all caught up on Cash Apps. Thank you guys so much for the support on both sides here. Let's keep going. I think I left off at question everything. Shout out to Anthony Allen with $2. He says, good afternoon, counselor. AV for president. Thank you so much, Anthony Allen. We are waiting for folks to come back from their lunch break. They should have been back at 1:15. It is 1:30. I mean, we knew they were going to be late, right? So too funny. But thank you so much, Anthony, for the super chat. Shout out to Mixed Chick Samantha. She is back with $4.99. She says, I was curious about the last part, trying to figure out if I can get the media to stream it. I thought that was odd. Yeah, so here's the thing. Law and Crime is the camera that we're watching right now. They are the main feed. And typically they source this out to other companies. So Law and Crime is one of the cameras in the room. Now, this feed is from Fox 5 Atlanta, right? So that is who I'm using to watch this, but it's through Law and Crime cameras. The other thing is 11 Alive is also streaming it. But it's interesting because like sometimes, Lead and I were using one of their streams, I think it was like a week ago, 11 Alive. And one of the bad parts about it was like you can hear like people actually speaking in the background. So it was like really hard to hear. But yeah, if media is streaming it, I believe it's like a Rule 26 or something along those lines. You have to get permission from the court to do it. So I don't know. I mean, I know Sylvia has permission as a press person to be in the room, but I don't know if she has permission from the court to stream. I would assume she does, but we'll go from there. We just saw a head walk by, so hopefully they're filing back in the courtroom at this point. But thank you so much, Mixed Chick Samantha. Shout out to Carmen. Hi, Carmen. Welcome. And thank you for becoming a YouTube member. You're going to love it here. You're going to love the perks. As soon as I have time to put them together, you're going to really like the perks that we are working on. So welcome. Shout out to Question Everything, who's back with $5. Question Everything says, if Woody admitted in the secret meeting that he murdered Nut, would his immunity still stand? Well, that's the question. And what we've seen from some court documents so far is that number one, Lil Woody said a few things. He admitted to killing Nut, but we don't know if he's telling the truth because he said he was going to lie. And she's just like, okay, well, if you do that, I'm going to charge you with perjury. So, if you're going to charge him for perjury, like, do we even know if Woody's telling the truth? He's probably lying. Because here's the thing. It sounds like he wants to help out the defense team. He doesn't want to be a, snitch. But like now it's being televised that he already did, that he has been talking to police for years, that, Young Thug, his friend, all of these guys were friends at some point. And they're watching Lil Woody be difficult on the stand and evasive for questions. But it's like, dude, we already know that you've been talking to the police. You've already talked to law enforcement. It's out there. It is out there. Does his immunity still stand? I think it does. That's why he chose to plead the fifth. That's why he's up there. He has like immunity against his will. It really does. All right, we see a few heads walking back and forth. All right, it looks like we might be coming back. The camera is moving. Before we do that, let me and we are all up to speed. Yeah, we're live. There might just be moving the camera. Could be a false alarm. Shout out to Anna P with the $20. Anna says, I'd really like your perspective on the disastrous Delphi case. Prosecution and judge have been so messy, it's hard to know what's what. If you have time, consider creating a breakdown of what's been going on. I'll look into it. I've seen the name, but I really don't know what's going on in that one, Anna. So I will add that to my list of things to do. I'll check that one out because we're getting some extra editor help on the channel just to get stuff out to you guys faster. But I'll look into the Delphi case because here's the thing, like these court streams are great. And this is why I do recaps for you guys, because sometimes it's just so daunting and half the time you have no idea what's going on. You're like, what does that mean? And I like popping in to explain that to y'all. You know, it's always a good time. It's always a good time. Well, thank you guys. I'm all caught up with supers. Let me come to y'all in the chat. What do y'all think is going to happen with these jail phone calls? Who's going to come out on top? Do you think the prosecution is going to be able to play all of the jail phone calls? Type a 1 in the chat if you think they're going to be able to play a majority of them, all of them. Or put a 2 in the chat if you think that some of them are going to be excluded. Let me know. All right, guys, it looks like we are back.
Copeland's examination. I'm going to include as the next court exhibit in order the email sent from Ms. Hilton to all of you on Tuesday, June 25th at 7:54 p.m. All right, so Ms. Hilton, from your email, it looks like that there are 5 calls that you initially provided 11 calls, but these are the 5 calls that
I got you, Lily, on the next break.
You are definitely going to play, and the other 6 may become relevant at a later time. And you say during your email, these do not cover jail calls that you intend to introduce to other witnesses later in the trial. So these are just the ones most immediate that you believe you're going to use to continue with your examination with Mr. Copeland. Is that correct?
Yes, Your Honor.
Okay. All right. So given that backdrop, I think the first one that you indicate that you are going to play is you have it marked as Index 58, March 11, 2015 at 19:27, and it goes from 00 to about 15 minutes and 30 seconds. Is that about right?
Yes, Your Honor. At this juncture, we haven't heard any objections from the defense.
Well, first, let me find out. Do we have any spokesman, or do you want me to ask each individual defendant? Yes, sir. Okay. Of Index 1, I'm using Ms. Hilton's email for purposes of this discussion.
And Your Honor, it will be State's Exhibit 401.
I was going to ask you that
Yankee.
next. Okay, it'll be State's 401 Yankee.
Yes, Your Honor.
And
Oh, these mics.
Mr. Steele, what's the part that you have an objection to?
Mr. Copeland is asking for a lawyer. I believe the state alleges that he's speaking with Mr. Jeffrey Williams for a part of that call at about that time, and that Mr. Williams uses my name, my first name, on the call. I would object and ask to redact that portion, especially my name.
Okay.
Yes, Tay-Biz.
Your Honor, in listening to that call, I don't believe he said Brian.
Can you play it?
What's the time?
Can you play the last 2 minutes? That'd be sufficient for me to listen to it, Mr. Steele?
Yes, sir.
Okay.
All right, first jail phone call.
Let's play the like 13:30 to the end.
Okay.
Okay, or 15:30.
Steele wants this out because Woody asked for a lawyer. And is talking about Young Thug.
Oh, thank you. Thank you.
Oh, sorry. That's not the right one.
Yeah, we've been saying Woody wrong. It's Woody, Quody. I don't know. I'm just going to keep saying Woody. I'm sorry, y'all.
Say what?
Ooh, here it is. Here it is, guys.
Look at your eyes. Yeah, they say.
You're right, we're gonna start at 13:30 or 13:33 now.
The police, let them jump on me. I see Nick crazy, man. Man, whoever has so many problems, whoever in the jail, all that jump ain't that. What should I say, man? What should I say, man? This shit here a drag, bro. Man, what the hell you talking about? You already know I know. You already know I know what's happening. Some of y'all out there, I was already like, what the hell, what they talking about? Now I'm talking about nobody. This what I'm trying to tell you. Man, I don't stop right in front of these folks and look at these folks calls that shit on the phone. Yeah. I made Bentley call her. Like, call her. See what the fuck going on. Because of probation. That's just a little bullshit. But the probation will try to hold you. Just because about their money or whatever. So I already know that. What I just said. I would just gave him a lawyer, look 3-4 band, $2,500. You know, he'll bring you.
You have 1 minute left.
They get you in the courtroom for $2,500. You know, that ain't shit. They don't even want that much. One lawyer had told me. I know. Yeah. So listen, I'm about to have this son text you my information. So you say you try to have me in the morning. Yeah, I had a lawyer or whatever lawyer you choose. I don't have none. Well, I could just have somebody pull up on their son and bring their son the money, and then you see what I'm saying, or they son mom or daddy, because you know they probably know something about the shit. So I can just make anybody go get the money. I can make them pull up to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure. Shit, we don't know no lawyer though. Yeah, you know what I'm saying? You know my lawyer. So I know mine. I ain't got the number. Hit him. You just tell him. Like, yeah, he already got my card and everything. He already got my card and his system and shit. So I ain't got the number. Just hit him. Like, go check on this number right here, and you can go check on this name.
Thank you for using Securus. Goodbye.
What in the hell was that?
I did not hear Brian or Mr. Steele's name at all.
I heard Brian.
Mr. Steele, do you, I can't say I just heard it either. Do you have a time reference you can point me to again? I'll listen to it again.
Very 15:12 is what I'm being told.
Okay,
I heard Brian.
Let's play about right at 15 minutes.
Did you guys hear Brian?
Please.
I heard that.
Hello.
Oh.
So that was a conversation with Young Thug.
Counsel, I'm going to listen to it through the ear audio system. You're welcome to listen to it as well again.
It's going to start at 15:04.
Go to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure. Shit, we don't know no lawyer though. Yeah, you know what I'm saying? You know my lawyer. So I know mine. I ain't got the number. Hit him. You just tell him. Like,
Said it right
yeah,
there.
he already got my card and everything. He already got my card and his system and shit. So I ain't got no number. Just hit him. Like,
you can stop it. It
go
does
check on this number right
Brian.
here and go check.
So.
Yeah, I heard him say Brian. He said, "You know Brian."
That's fine. We can stop it right before that portion.
All right. Mr. Steele, any further? They're going to edit. They're going to not play that. I do hear your name. At least what's represented to be Brian. So that will be excluded. Do you have any? Does anybody else have any specific objections as to any other period that call from 000 to 15? About 15 minutes, 10 seconds or thereafter. Mr. Weinstein. No, Your Honor. Mr. Matthews. No, Your Honor. Misty Williams. All right, Mr. Botts on behalf of Mr. Nichols. All right, Mr. Short. No, Your Honor. Okay, anything further, Mr. Steele? In regards to that section.
Not the part that you just ordered to be staged or not played.
It's not going to be played.
Be clear that we're not just playing his name, but the fact he says, "You know my lawyer," and we'll stop where it says Brian, and then we'll play after that as well.
All right.
I don't know the relevance, and then it gets cut off. So I'm objecting to that.
To the relevance of, my lawyer,
Yeah,
or that part of the tape?
what difference does that make?
Okay, state?
We believe that as a part of the RICO conspiracy, the fact that the leader is offering up his lawyer to pay for another co-conspirator
come
to get
on.
out of jail is relevant information. Who
Wow.
it is, that's fine. But the fact that he's offering up his lawyer for another co-conspirator is relevant.
Mr. Steele, anything else?
Yes, it was a conversation that got cut off. If you look at the records.
It did
or
get
the
cut
state
off.
office to look at the records. I did not have anything to do with Mr. Copeland ever.
Yeah.
I don't know who represented Mr. Copeland, so I believe that it is irrelevant. It's just a conversation that was then cut off. So you don't get the entirety of the thought. So I do, if they're going to argue, they being the state's going to argue, oh, Mr. Williams is going to use his personal lawyer. That's not a true statement, so it's misleading. It's an incomplete, it's unfortunate, but I don't think anyone.
It is an
I
incomplete
think the
sentence.
securist cuts off at
15 minutes, yeah. The other thing is, I think that, the court heard there's some conversation prior to that, because we played the last 2 minutes in regards to representation. So I think that's what it's made in reference to.
Yeah, that was harsh.
Even though
Mike.
they don't complete the conversation. But Ms. Hilton, anything else?
That will go to weight, not admissibility. He can surely ask, if he chooses to ask Mr. Copeland any questions, did you ever get a lawyer? So he can ask Mr. Copeland that question.
Mr. Steele, anything else before I rule?
I just don't think it's needed to say my lawyer. That's what I'm objecting to. I don't mind the conversation about, I need a lawyer. I think Mr. Williams says, get any lawyer you want, something to that effect. It's not a quote. But I don't see the need to say, I have my lawyer, I have his business card, I can call my lawyer. I don't see how that is relevant. And then it gets cut off. So I don't know if that means what the state is saying is, oh, and then he's going to get Mr. Williams' personal lawyer for Mr. Copeland. That's not what it says.
And that would be certainly speculation.
That
would be speculation, but I think they get at least to play, based upon what they proffered so far. I think they get to play it. And also it's very limited as to what it can be said about it. Because unless Mr. Copeland, has some frame of reference.
They shouldn't put that in front of the
I don't
jury.
disagree with that, but I would like to leave it after I need money for a lawyer. These are not quotes.
Oh my God.
But, they're discussing, I need money for a lawyer. I don't know any lawyer. A statement is made, we'll get any lawyer you want, and then just end it there, rather than I have my own lawyer and I have him on Rolodex or whatever I don't think Rolodex would use, but whatever those terms are, at that point I would end it. That's my request to the court. I also object.
Let me see if the state has any
Your Honor,
further issues to that.
Your Honor, relevant evidence is any evidence that tends to prove an issue. We believe that the fact that the leader of the gang is offering up his lawyer to his co-conspirator is relevant for this jury to determine whether or not there is a RICO gang conspiracy. And so we believe that is relevant, because the argument is relevant. It also comes in because it's a party opponent admission. This is the defendant Williams telling Mr. Copeland that I will provide. He said, specifically what Mr. Copeland says is, I don't know any lawyers. And he said, you can call my lawyer, is what he actually says. So I think reading it in context, he's saying, okay, you don't know any, but I'll provide mine, or you can potentially use mine. Whether or not he used him or not, that is a question that can be asked of Mr. Copeland. But the fact that he was willing to offer up the lawyer is what is important, not the result of it.
Right. Sir.
I think this is a very bad point in our community if we are now going to say offering to get someone a lawyer is part of a RICO conspiracy. This is a probation revocation case on supposed non-compliance with community service. I know you haven't heard the whole.
I haven't, sir.
That's what the recording before we started at 13:30. That's what it's about. Mr. Copeland says, and it basically mirrors what he said on the witness stand. He said The police had me locked up. These are my words, trumped up charges because my probation officer didn't take out a warrant on me, but the supervisor was asked by the police to take out a warrant on me because of community service hours. I will be getting out on Friday. This is a Wednesday. I'll be getting out on a Friday, and I believe it's a Wednesday. I'll be getting out on Friday when I go to court, but I don't have a lawyer, so it gets continued for me to get a lawyer. So I'm held hostage basically by the way the courts are. So Mr. Williams is not part of any of that conversation. He then allegedly gets on the telephone and has a conversation, and that is explained to Mr. Williams as well. I go to court Friday, but I don't have a lawyer.
Are they still on this?
To then say that it's part of a conspiracy to get a lawyer for someone going to court on a probation revocation case, I think is a bridge too far. To say you're going to get a lawyer, I don't have a problem with that.
Yeah.
To say I offered
Brian's
my
right.
lawyer because that is a symbolic.
He better not rule. He better not rule in the state's favor. Brian's right. Like, he literally, first of all, I agree with him that the conversation got cut off, because you can hear those jail phone calls. If you've ever been on the phone with somebody from jail, they're like, you have 1 minute left. You know, you have 30 seconds left. And then the phone call ends. But just because Young Thug says, I have, you know, get an attorney, I have an attorney, you know, Brian, I got a lawyer, you know, he has a lawyer. It doesn't indicate anything. And then the conversation cuts off mid-sentence. I agree with him. I don't think it's relevant. And then for the state to say it is relevant because it shows that the leader was making arrangements. He was scrambling and scraping to get Lil Woody an attorney. Imagine if Steele was Lil Woody's attorney. I mean, I don't see how this is a strong argument at all. So we'll see how Simone does with this one. But I do not think that this is a strong argument by any means.
Is symbolic of a crime. Seems to me that if that type of evidence comes in courts, we are all in trouble, because that's what we want people to do. We want people to get lawyers. So I'm objecting to the state's playing that portion. I'm not objecting to the portion that Mr. Williams allegedly is on the phone and is offering to potentially help with a lawyer. I don't have a problem with that. If the state wants to then argue that's somehow part of a conspiracy, I'll argue against it. But to then go further and say, aha, and this is the crime organization and the lawyers are part of criminal activity, I think that is under 403. It should never be said in any courtroom unless there's proof of it. That lawyers protect criminal parties.
Your Honor, the state never said, I don't even know where Mr. Steele got that last assertion from. The state said what is relevant is that he was willing to offer up his attorney to represent him. That is where it ends. And everything else Mr. Steele said is great for closing argument. But the relevance of it comes in, and then he can argue all of that, what he just said in closing.
It's relevant. It's more probative than prejudicial.
Oh my
I'm
God.
going to go ahead and I'll allow it. I'll give you a continuing objection, Mr. Steele, in that respect.
Wow.
Okay. All right. So what was the next thing you wanted to
He ruled with the
argue about,
state.
sir, or have me invite my attention to as to the first call? Is it the first call or another call?
This is this call, but it's going to be for
Okay.
all of the calls.
Okay. All right.
There's portions of it that are just conversation about what other people said. I'm just using example. Val, V-A-L, said that.
I don't, Michael.
Have 1 second.
In this call, Mr. Steele,
I just
or
think
different?
she's wrong. I don't hate her.
Oh, I'm sorry. I don't. Your Honor, if you can ask, are we addressing the March 11th call?
I was gonna ask him for that clarification myself. Mr. Steele said it was this call and other calls, but he's making, for example, and I think he mentions Val at that point in time, but I wanted to find out, is Val on the first call, second call?
I think this June 10th call, which may be the second call.
Yes, June 10th. That's the one at 2038, 4212, 10, 44. I'm sorry, 4 minutes, 12 seconds, 4 hours. Is it four? Is it hours, minutes?
It's 4 minutes and 12 seconds to 11 minutes and 10 seconds.
Okay, thank you.
But so can we just either close out or finish March 11th? So we can
All right.
stay consistent, but the state will ask the court.
I was attempting to say, but it's
eardrums.
going to be overarching, but I could do it individually. So on each call, there are conversations about what did someone else say. So Mr. Copeland allegedly, his voice is speaking with his girlfriend or significant other or the mother of his child. And he is saying, what did this person say? Well, this person said A, B, or C. I'm going to be objecting, I am objecting to anything that is hearsay. So for instance, in this call, Shannon said something. I'm not saying, Mr. Sharp and Mr. Botts can handle that for Mr. Stillwell, but I'm objecting to any third-party hearsay. They're not even on the call. I understand also that if Deshawn is not being called as a witness, which I believe she is not, I'm sorry, I shouldn't say the significant other, Mr. Copeland, I do not believe the state is going to call her. I don't know why her voice gets to be played on these.
Oh, Little Woody's baby mama.
She's somehow an exception to the hearsay rule. So I tell you that, Your Honor, because that is infected on each of these calls, because clearly there's another party on the call.
Another party that Mr. Copeland's talking to?
Who will not be testifying and who has not been classified so far as a supposed co-conspirator.
So, Your Honor, before we even get to these generalities, if we can just talk about each individual call, because I think it becomes confusing and timestamped, so we can know what you're objecting to and the basis of your objection, because some of what Mr. Steele is referencing, there's exceptions to why this should come in. And so I think that we need to take call by call what is being objected to, so we can respond accordingly to that particular section.
You all have transcripts of these calls?
We do not have transcripts of the jail calls, but they're clear enough that you can hear what the issues are.
All right. The challenge that we're going to have is, without a transcript, you're going to have to play these calls for me. Then each particular segment, unless you've identified that already, or this defense, Mr. Steele, I think you all are going to have to identify that, because what's going to happen is, if it's played, we're going to end up having this continual objection and potentially putting our jury out for periods.
Okay, here's why this case is a logistical nightmare, because exactly what Glanville is talking about right now. I thought they had transcripts for these phone calls. He just asked Simone, like, hey, do you guys have transcripts for these phone calls? And she said no, because you can hear them. So it looks like they only worked on transcripts for the interrogation footage because it was bad audio. But at the same time, they know better. Like, why didn't the state do this? Like, you got six, 7 people sitting on the state side. Somebody couldn't type this up. Somebody couldn't use ChatGPT to transcribe this. You couldn't pay a third party to get it done. They are going to need transcripts, because look at, like, Steele is listening to something. He's already got objections. But what he's also saying is he's got objections to all 5 of those phone calls. And what Glanville is saying here is like, all right, guys, well, how are we supposed to keep track on what is said in the phone calls? So this might actually be another delay, because if it's not transcribed, how's it going to work? So I'm going to skip back 30 seconds to see when Glanville starts to talk about having these transcribed and the benefits that it would have for the court, especially, we want to move along. We don't have time for this.
But you all are going to have to identify that, because what's going to happen is, if it's played, we're going to end up having this continual objection and potentially putting our jury out for periods of time to have me adjudicate that. So is it possible for you all to listen to the tapes, to the jail calls, and then flag those portions like you did for his interviews, to have me rule upon those? Because I understand what you're saying, Mr. Steele. It's a valid point. But what I don't want to do is, I want to minimize the disruption in front of the jury. So if we have agreement, then, or if you need to just object, I'll say as earlier noted. So, yes, I think that would be a much better way to potentially present this.
I could have that. I didn't write down the timestamps, but I could do that.
Yes. And then you could tell me, for example, to go to, 12 minutes and 15 seconds, it's hearsay, it's not within any exception, or it's speculation, or, whatever. And I'll let the state respond, and I can rule, kind of similar to what I did with the audio videotape interviews. If that's the case, I think that would probably be a better use of our time.
And again, Your Honor, the portions that we sent an email yesterday are the portions we intend to play. So there's only 2 calls that we intend to play the entirety of it, but the other calls we've broken down specifically the areas that we think are relevant. So
Okay, the first call is like 15 minutes.
so only the first and the 5th call are the full 15 minutes. The calls are 15 minutes. So only the first and the 5th, we intend to play the full calls. However, calls 2.
Is that the June 10th call at 2038?
Yes, Your Honor. So in the June 10th call, the only portions we intend to play is 4:12 through 11:10, and then picking back up again at 11:45 through 15:26.
All right.
And then for June 13th, the only portions we intend to play is 00 through 6:05.
That's still a fair amount of time, though.
It is. So they definitely are, but I just want to make sure that they're not listening to the whole tape and saying, I want to just keep the guides of what we intend to play, so defense knows the parameters that we intend to play when they're reviewing it to determine their to determine what they're objecting to.
Okay. Ms. Steele, give you just a thought. I need to consult with Ms. Chandler in just a second. How long do you think that would take? And I'll just ask you and come back on the record, okay? All right. I'm just going to recess in place.
Okay, he's taking a second to chat with his staff. We're going to see if, and no one has to leave the courtroom. He's just having a quick conversation. So it's a quick conversation to the side, not a sidebar, but they want to see how long it will take to get a transcript up and running, to have both parties review. I mean, again, this jury is already pushed back. We do not have court tomorrow or Friday. The idea today was to get all of this settled, to get these phone calls done. So that way, when the jury returns, we are ready to show them things. We're ready because of this entire delay has been caused by Woody, actually. And that's a side thought, but look at how much Woody has caused. The last 2 weeks, last week and a half, we've had to look at actual interrogation footage, listen to his jail phone calls, transcribe the jail phone calls. It's insane. It is insane. Shout out to Civ, who says ChatGPT don't do ebonics. I mean, I don't know, guys. What do y'all think about this whole thing? It's going to cause more time to go by. And the longer that we take to do this, the longer it's going to take for, the direct examination of Woody to continue. This guy was sworn in weeks ago. The entire month of June, he's been on the stand. Shout out to K-Way, who says trial by ambush. I mean, they should have been ready for this a long time ago. Shout out to Wheezy, who says, AV, they got a lot of nothing. I mean, Brian says, what you mean? What do you mean? What you mean a transcript? ChatGPT, what you mean? Too funny. While we're waiting, I'll read a few. I think we got a few supers that came in. Shout out to my Virtue staff with $20. Who says, AV, giving some support on this channel also. Thank you so much, my Virtue staff. It's good to see you on this side. Really, really good to see you. We don't have the game show vibe going on. I don't have your dinette set over here, but really happy to see you on my side. Shout out to Anna P with the $4.99. Anna says, I recommend our family attorney to people all the time because he's great and honest. Am I a part of a RICO now? I love that, Anna. I mean, well, that's the thing. We're looking at Steele, and I think it was more of a casual conversation. I did bring up a few of y'all's comments. Some of y'all did think that was relevant, right? Some of you guys did think that Thug was offering the name of his lawyer to help Woody. Woody's calling him from jail. Who knows? But what's important is how the jury's going to interpret that. So they're going to use a part of that statement. They're going to take the part where he said, Brian. They're going to take the Brian Steele part out. So they're just going to cut it right there and not play that part. But it does show that they had a conversation about lawyers. Apparently, that is corroborating the criminal enterprise. We'll see how the jury takes it, but that piece of evidence is going to be played for them. But yeah, Anna, that is hilarious. That is hilarious. What else y'all got? Queen says, who wrote this skit? Too funny. Steven says, do you think the judge is continuously going with prosecution because they are Black? No, I think he's ruling in his ways. I think he is. Sometimes I don't agree with his rulings. Sometimes I do agree with his rulings. He has been a little bit more defense savory this week, but it's hard, Stephen, because everybody in the courtroom is Black. Everyone, except for Shard and Steele. But like a majority of the folks in the room are Black, so I don't think it's racial at all, to be honest. Let me bring up Lily. Lily did ask this question earlier, and I started. She said, AV, can you enlighten us on Kayla being removed from the hearing that's taking place next week? Well, I don't know if she has been officially removed. I doubt that, because as of Monday, when we spoke with her, she said that she's going to be in attendance in that meeting, even if it gets pushed. She has to be. Otherwise, she's going to be held in contempt. And let me see. Maybe I could pull up the actual document. Let me see. Order to show cause Glanville. I don't think they removed her at all. When did it come out? It came out 6/24. Yeah, I don't think they removed her, but she should still be in attendance for that meeting. She has to be, because she was in the original meeting. All parties that were there, and if she doesn't go, they're going to hold her in contempt and put her in jail. So, she's still going to be going to the hearing for sure. And while we're waiting for good old Judge Glanville having a side conversation, I'm going to see what I can find as far as the document itself. Yeah, as far as what I'm seeing, she still has to come. She still has to come. Kayla did want Judge Glanville to recuse himself. So she filed a motion to quash and a motion to recuse. I'll look for it when we have some more time. But as far as I know, Lily, she still has to show up. She still has to show up. Shout out to FFS with the $4.99. He says, on the bright side, the longer this takes, the longer we can watch you, for fuck's sake. So it's a win. It's a win-win, to be honest. That's true. The longer it takes, we all get a chance to hang out a lot longer. So that is going to be fun. Thank you so much for that one. That is a good point. Shout out to Anthony Allen with $2 who says, prosecution doing last minute homework assignment. They are like last minute transcribing this. It's taking way too long. They should have transcripts, and we all know that. Lucky Lika says, wow, no transcripts. I don't understand half of what he's saying. Yeah, and that's the thing. You have to look at it verbatim. What did Lil Woody say on the phone calls, right? The conversations he's had with Thug on the phone calls, the conversations he's had with his baby mama on the phone calls. And Steele, you guys saw Steele trying to get those conversations removed because, what does she have to do with the case? Can we mute her parts? Ooh, they are back. Clearly.
Okay. All right.
Shout out to Austin. He said, Woody's a menace. Someone asked for a Supreme Court update. We still don't have it yet. As of probably like 20 minutes ago. Nothing yet. Yeah, he totally does not want to testify.
Okay, folks. I'll just direct Mr. Adams and Mr. Steele. You all go ahead and do that at this point in time and then send what you feel you must to the state. And then we'll take it up either Monday, the 1st of July or Tuesday, the 2nd of July. As part, we left the Tuesday open anyways, the 2nd to complete whatever was not done. So I think that we could probably handle that fairly comfortably on that morning of the 2nd, Tuesday the 2nd. Set. Okay. All right. So let's just plan on taking that up Tuesday morning, the 2nd of July, when we start court. I'm gonna probably leave in probably about an hour. But tell me where you all are.
Would it be an impeachment on anybody if we got it in writing by tomorrow morning? That'd be okay. If it's not,
That's perfectly fine.
That's fine, Mr. Steele. Let's say by noon tomorrow. Would that be sufficient?
no problem. Yes.
Okay. All right. Okay. So we'll take those up on Tuesday, July the 2nd, 10 a.m.
All right, so it looks like they're going to transcribe what they have a problem with, send it over by tomorrow, and we'll talk about it on Tuesday. So they might actually be wrapping for the day, but let's hang on and see if they have anything else they're going to be covering. Chopped and screwed, cat. Chopped and screwed.
Okay. Anything else we need to take up at this point in time?
Nothing from the station.
Anything from the defendants?
No, sir.
Okay. Monday, the 1st of July. As I mentioned earlier, we'll bring your clients over. They'll be here. I'd ask counsel to meet 8F jury room for Monday at 9:00. All right? For the in-camera review.
And on that, Your Honor, again, and I know I said it, so I'm assuming that it's preserved, but Mr. Williams would like to be present
Yeah, you told me that already. Do you have any additional case law other than the United States Sixth and Georgia's Sixth Amendments?
Georgia's Article 1, Section 1, Paragraph 12, I believe, Mr. Williams, I need him there to review. I assume we're getting a transcript. I don't know if that's.
I'll cover that on Monday. Mr. Williams will be brought over, but the part that you
Oh.
all are here just for in camera, that's attorneys because of the privilege potential that is that may be discussed, or no, I said not discussed, identified. And you all as lawyers are of course subject to the rules of professional responsibility. Third parties or your clients and other people are not.
It got rescheduled.
I oppose that
Warren Winter.
objection.
And sir, if I have anything else, I will certainly reconsider that. But at this point in time, for that particular purpose, until we get through the in-camera review, when the transcript is reviewed, the court's intention is to review everything for for Brady and/or impeachment. And then I will flag all those, and then anything else that you all wished for me to consider, you can mark, and then we can have a discussion about that.
Okay, and I'd like it done in open court as well, in Mr. Williams' presence and in open court.
Okay, I don't think he can do, until I identify it, Mr. Steele, and make rulings on it, he doesn't have the right to be present. You're the person that's present for him at that point in time because it covers privilege. It's just like if you had defects records, okay? You and Mr. Williams could not come to my chambers and review those records. You could, but he can't. Now, once I've ruled upon those, of course, I will copy whatever periods of the transcript, portions of the transcript that I believe are appropriate, and I will make other rulings in regards to sealing that particular portions which are not for any other review, and then you can take that to Mr. Williams, and all of you can talk about that.
I understand. I just.
I know you've made an objection as to that, as to your client's presence, but for the privilege or for the in-camera review, he doesn't have the right to be there. I respectfully disagree, but.
I understand that we are in disagreement, but I'd also like to then wait. Open court, I believe.
Ears.
Court as well, and that's under Article 1 and.
Okay.
The first in the.
I understand that. I agree with you about the open court. I understand about the open courtroom. I agree with you about the respective constitutional provisions. I disagree with you about the in-camera. That doesn't apply to an open courtroom. The in-camera review of these records. So we'll just, like I said, if you got some case law, you got something for me to consider, I'll certainly look at it. But at this point, that's what my ruling will be in terms of your client's collectively presence. However, like I said, once the court makes those determinations as to which things are to be released to you, and I copy those transcripts for you, those portions or the transcript for you, then your clients will be here and you may take those portions and discuss those with your clients. Okay. And then we will have the rest of whatever we have in open court. Okay.
Understand the rule.
Okay. All right. Like I said, if you have some case law, you want me to look at something, I'll certainly look at it. Because I
believe that under United States and Georgia Constitution and Presley, it's a voir dire issue, but I believe this should all be done in open court, not in a closed courtroom or closed chambers, jury room.
You are correct about anything else, but when you're dealing with a matter of privilege and or depending upon the type of records you're reviewing, not everybody gets to see those. And that's where we disagree. That's not an open proceeding. That's a closed proceeding to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to your argument about that. That you don't get an open courtroom for, because I have to make a determination of whether or not first you get it and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's.
Guys, let me just chime in and explain what's going on. So the judge and Brian Steele are going back and forth right now. Why? Because we're about to end the day. And the judge was basically telling us what we are about to do. We don't have time to transcribe the jail phone calls right now. We are going to send them to each other tomorrow, and there is no court on Friday. That leaves us with Monday, July 1st. What is also happening on Monday, July 1st? Right, so we're going to have these jail phone calls continue on Monday, July 1st. But at 9 a.m., the in-camera review, and remember what in-camera means. I know you think of an actual camera, right? You think of one of these when you hear the words in camera. That's not what it is. An in-camera review means off camera. It means behind the scenes. All the attorneys, all the defense attorneys in this case are to report at 9 a.m. on Monday so they can finally look at the transcript from the secret meeting. Judge Glanville told us what's going to be in there and what will not be redacted. We're going to get Brady material. So that is anything that would exonerate any of the defendants. That is going to be in the transcript. We're going to see anything that can be used to impeach Woody. That is going to be included in the transcript. And when I say impeach, I don't mean it from the prosecutor's side. I mean it for the defense attorneys. So if they want to impeach Woody, they are going to have material of it made available to them in the transcript that they're going to be able to use. Now, what is Steele and Glanville going back and forth on? Now, when this got rescheduled, Steele he was very adamant that he wants Young Thug in that room too. He's saying that his client deserves the right to be in that room to hear everything. Judge Glanville is saying, no, he doesn't have that right. Unless you have some case that supports a defendant being in an in-camera review, unless you have some type of case law that supports that argument, my answer is going to be no. I'm going to deny it. You are his representative. You are bound by the rules of professional ethics. And guys, attorneys, not only do you have to be barred, you have to take another test called the MPRE before you take the bar exam. I've already took it and passed, but it is called the MPRE, the Model Rules of Professional Ethics. You cannot practice without abiding by those rules, right? Do people break the rules? Yeah, all the time. That's when you could put in bar complaints, because attorneys have to abide by those rules no matter what. One of those rules is confidentiality and privileged, right? Privileged information. This is kind of what Judge Glanville is protecting. There's some information that took place during that meeting that is privileged, that can't get out. That is attorney-client privilege. So one of the lawyers, something between a lawyer and a client, is being protected. They can't disclose it. So Judge Glanville doesn't want anyone who is not an attorney in this meeting, right? He doesn't want anybody to look at the transcript, and because he knows that he can trust the lawyers to keep the information confidential. I don't know if you can, given everything that's gone down with moles and the like. Who knows, right? So he is going back and forth with Brian on this right now, and Brian's like, no, Young Thug has a right. He needs to be in that room. And he's just like, well, no. And here's the other thing. He's like, okay, fine. If Young Thug can't be in the room, I want the information that's on the transcript to be read out in open court. Brian's very toned down today because he's not trying to get into it with Judge Glanville. And Judge Glanville is trying to control himself, but you could see that he's a little annoyed. So we're going to go back into that interaction. I'm going to go back about 30 seconds so we can catch up, because this is probably the final matter that they need to talk about before we come back on Monday. All right. So I hope that explanation helped a little bit. But why don't I go ahead and bring us back a few seconds?
Casting to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to your argument about that. That you don't get an open courtroom for, because I have to make a determination of whether or not first you get it, and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's why, or else I give you the entire transcript. It would be fine for me, but I think that that's the issue.
If an attorney-client privilege conversation was captured by the court reporter on a transcript with the court present, it can't be attorney-client privilege.
Well, that's for another body to resolve, not me. And you'll have to first decide whether or not those conversations were had. So once you take a look at the transcript, then we can have the conversation again, because that will affect whether I seal it or not.
That's fine. I'm just want to continuing. I've voiced it, so I think it's preserved. But
I think you've said it now 3 times. I think you've gotten your point across. But again, I'm going to tell you again, if you've got a case which says your clients can be present, I'll be more than happy to listen to you. I really will.
Well, my case is every case, but Penny,
Ooh.
P-E-N-N-I-E versus State,
Ooh.
Sammons,
Ooh.
S-A-M-M-O-N-S.
Oh, Brian got cases.
Ward, W-A-D-E versus State, 1852. But the bottom line is, and they all say the same thing, at any critical stage of the proceedings, the criminally accused has a right to be present. I'm raising under federal as well as state constitution. I'm also raising an open courtroom, not a closed courtroom, under the right.
Brian's going in, guys.
Public trial.
I understand that, sir, and I'll take a look at the cases you cited, and that is part of what the court has to rule upon, whether or not it was in fact, or whether or not somebody else will rule upon, not me, I should say, whether or not it's a critical stage. But let me get through the review of the in-camera review first, and then we can have some other conversations. Okay?
No, I understand how it works. I just object. You're overruling it. I'm just
okay. All right.
Thank you.
State, you'll be able to as well join for those of you that were in there as well. I believe Ms. Hilton and Ms. Love for that same review. Okay. All right. Okay. All right, folks. I'll see you on Monday. All right. Enjoy the rest of your time.
All right, guys, look at that. We got a little bit of a heated exchange. Court is now done for the day. Oh, that horrible audio is too. And my birds are back. I don't know. This has been a fun-filled day. I'm going to read a few supers and we'll go to wrap for the day. But wow, it's a big thing. We have Monday. We have the big day where they're going to look at the transcript. Finally, they're going to take a look at this transcript and see how it is going to benefit the defendants. It's going to be interesting to see how that plays out. Let me go ahead and catch up on some supers here. I think I left off at Anthony Allen. Shout out to JC with the $2 who says, shout out. Thanks for the great coverage. Hashtag MAGA. Hashtag MAGA. MAGA people are here today. Thank you so much. Mr. Told You sends me $5. Thank you so much. He says, shout out to AV just tuning in. Thank you so much for tuning in. I appreciate you. Shout out to Civlap. I hope I'm saying that correct. Civlap sends a super sticker for $3. Thank you so much. Shout out to, I make fun of you. The main man, your main man Mush, the Mushroom Podcast with $5. He says, wasn't Woody in the judge's chambers already? He was, but that's not who we're talking about. Woody was in there. But what Brian was just arguing, Brian wants young Thug in there. He wants one, and Young Thug is the defendant. But here's the thing. Young Thug is being charged with being the mastermind behind this entire RICO operation. He is being charged with being the mastermind behind all of it. The King Slime. And they want, and so one of you guys had mentioned it, doesn't he have a right to confront his accuser, right? Well, the judge is afraid. It's almost like a balancing test. He is afraid of the privileged information coming out. Brian Steele's just like, okay, but like court proceedings, my client has a right to be present with any major parts of court proceedings, right? And they didn't get into it too much, but Brian was just like, I'm noting this for the record. You better appeal. You better expect that this is gonna come up on appeal, because this is another ruling that wasn't necessarily found. Brian stood on his square. He went back and forth with him at least 3 or 4 times. He's like, I'm objecting to that. That's not right. It's not fair. It's not a sound ruling. And Judge Glanville's just like, well, you can take that up with someone else. What does he mean by that? When he says you could take that up with someone else, he means on appeal. Someone else is going to look at that for a review. And notice that his language changed when he says you could take that up with someone else when they have someone else look at it. Why? Why did Brian say that? Or why did Judge Glanville say that? And some of you guys called it because of this. Because of this. He knows that the Supreme Court is looking at him. They're watching him right now. This is still docketed. They're looking at how he rules on things. He knows that this ex parte meeting, the transcript for the secret meeting, was one of the reasons why this went to the Supreme Court, because he wouldn't make it available to the defendants. Now that he finally does, here's the other thing. They're asking for a little bit more. They're asking for the defendants to be able to come to this meeting, and he's saying no. So when he's using his words very, very carefully and saying, okay, I'm going to give you a little bit of rope, but Mr. Steele, if you have some cases to support your position, I will gladly hear you out. It's almost like he was gritting his teeth saying that, like, oh, I'll hear you out. He was gritting his teeth saying that. And he pulled an Ashley Merchant, like, oh yeah? Here's the thing. Not only does he have co-counsel, so Young Thug is sitting in between both of his attorneys. Adams is on the other side. If you guys also notice, when you look at that table, they also have 2 young people right next to them. There's a young woman sitting next to Steele, and there's a young man. Notice that Steele stood up. He kept arguing. He sat down for a second. Those paralegals, I'm guessing who they are, legal assistants, had those cases pulled up. So Brian was able to start citing cases. Like, oh, you want to see cases? Here's 3. Brian actually used 3 cases right then and there. Judge Glanville didn't decide. He was just like, oh, okay, well, you're going to have to take that up and have somebody else review it. Like we always see with him. Like we always see. So your main man Mush, you got me on a little bit of a rant there, but I had to explain, like, yeah, Woody was in chambers. But he's in chambers as a witness. Can a defendant meet them in that conference room at 9 a.m. to look at something that concerns him? It's a major part of it. So, those are, we all are afforded that. Constitutionally, we're all afforded that. But that's what we saw just then and there. So interesting stuff. Shout out to Don Allen with the $9.99. He says, how is anything their attorney-client privilege with all those people that were in the room? Exactly, Don. It's a wonderful question. It depends. Something was said where there was an attorney-client relationship, and I wonder if it's Woody and Bumpus. Because in that moment, they were still in an attorney-client relationship. So privileged information was divulged. Unless there was another lawyer in the room that wasn't on the state side, that's my best guess. Something that Woody said is being protected. Something. Some of it has come out, but not all of it. And Judge Glanville is scrambling and scraping to protect it. That's what's happening. That's what's happening. Shout out to Jack Glanville, the service dog. I didn't know you could super chat, man. And you got them thumbs, the paws. You're sending super chats, no comment, no question, pure love of the game. Jack's been chilling with us behind the bench and tuning in. We love that. We love to see you over here, Jack. Thank you so much for the $9.99 super. Shout out to FFS with $1.99 says Brian just gave him a huge fuck yourself sandwich. I mean, he did. He did. And Brian was polite about it. And you could tell Judge Glanville tried to be polite about it. But these guys have been butting heads for months. And after he put Brian in contempt, imagine if somebody publicly humiliated you in your professional career, tried to put you in jail for disagreeing with them, and you're doing your job for your defendant, all while being wrong and making or having an illegal ex parte meeting, all while doing that, while this is televised nationally, And you still have to go in front of that person, even though the bond was granted, you still have to go before them every day and appear as if you know, professional. You have to appear professional, as if you didn't disagree with that. And there's still, you could tell there's still a mood in the room between these two. They have to be careful with what they say. And I think what we just saw there was a beautiful display of that. Beautiful display of that. It was super, super interesting. All right, let me read some Cash Apps, but I hope you guys enjoyed that as much as I did. I was just like, oh, Brian, turn it up. It's getting real. That was like the tea of the day. It totally was. Shout out to Freddie. Freddie hits me with a 5. Thank you so much, Freddie. Freddie says, Woody, what we gonna do with the sound engineer he fired? The sound, oh my God, did you guys hear that? For those of you wearing headphones like me, that was, it was excruciating. I was melting in my chair. It was so tough. It was so tough. It was so tough. Shout out to Kenji with the 250. Thank you so much, Kenji. Kenji says, good to see the great breakdown. Thank you, Kenji. Really, really sweet of you. All right, guys, I'm going to go ahead. Oh, look who it is, guys. Shout out to Legal Ray with the $4.99. Thank you so much, Legal Ray, a new brand spanking new content creator and rising third-year law student who is starting her legal journey here on YouTube. Welcome to LawTube, if that's still a thing. If that's still a thing. Let's just call it the legal space. Legal Ray says, what if he was a pro se defendant? He would be present then. So just because he's privileged enough to afford counsel, he loses that right? Makes no sense. Yeah, I mean, I think Glanville's dead wrong here. And, you know, a lot of people are like, you just don't like the state. You just don't like Simone. No, I like Simone. I have a lot of respect for her. And here's the other thing, guys. Let me show you this. Let me show you this. I looked her up. She's got some great credentials. She's had an amazing career. Oh, let me see. Share screen. Look, here she is. I looked her up. I looked this up on the Fulton County District Attorney's Office website. Simone is tenured, right? She is a deputy district attorney. She leads the Special Victims Division, right? Under the Domestic Violence Unit. She's been with the District Attorney's Office under Bonnie Willis, and she's been there for years, right? She's worked for DeKalb County, right? And she's specialized in some of these things. She's even fought against crimes against children, DV, SA. She really tries to help victims. Okay, she's handled cases that were drug offenses, homicide cases. She started her prosecution career in 2010. That means that she's been practicing for about 14 years. She received several awards: Major Case Rookie of the Year, the Trial Unit Attorney of the Year. She was selected as a rising star in the Fulton County District Attorney's Office in 2012. She was, you guys are going to love this, she was originally born and raised in Philly, okay? And she made Georgia her home after graduating law school. She has a degree in legal communications from Howard. She received her JD from North Carolina Central University School of Law in 2008. And she's got some accolades. She's a proud member of the Delta Sigma Theta sorority. Shout out to the sorors. She's got a career on her. But at the same time, when there are rulings like this, it's not even about the state. It's about Judge Glanville being the referee between these two parties, between the state and between the defendants, in an unbiased way, protecting everybody's rights. Okay, the rights of the victims from all these RICO things, but also protecting the rights of the defendants. He has to do that. That's his job. Is he protecting these 6 defendants' rights while also being balanced and unbiased? And I think that we've seen over these past few weeks that the answer there is no. He hasn't been completely impartial and unbiased. Legal Ray, you're watching it like me, coming up in this game and seeing, Brian Steele willing to put it on the wood and go to jail for his clients. So It doesn't make sense. I agree with you. And I'm so proud to see you here on my side. But the shenanigans just don't stop. They just don't stop. We've got the next few months are going to be interesting with this case. Shout out to Civ Lab with the $5. He says Steele isn't being polite. He's still smarting from being locked up. It's called passive aggression. You know, I was trying to be nice about it. I was trying to be nice, Civ, but it's a little, I think it's coming from both sides. It's coming from both sides. Shout out to Harlem Lady T. Thank you so much with the $1.99. She says, will another judge be in the room on Monday? No. In fact, they will not. I hope we can see the Supreme Court do something between tomorrow and Friday to prevent that from happening. But as of now, Harlem Lady T, no. Judge Glanville will be in that room with the defendants. Court reporter probably, but they are there in camera to review this transcript. That's where we are right now. It's a little crazy. It is a little crazy. All right, guys. Well, listen, I have been streaming for about 4 hours. I am happy that we were able to cover a lot of this today. Thank you guys so much for watching. I want to give a huge, huge, huge shout out to our stream sponsors, Mike and 10. If you guys could do me a favor and type in Mike and 10 in the chat, that would be fantastic. Huge, huge, huge part of my community, huge part of the lead attorneys community. Great guy, amazing, amazing person, and super generous. But I also want to give a huge, huge, huge shout out. And if you guys could type her name, spam her name in the chat, to Jazma with $200. I want to thank all of you guys for sticking with me. You know, I don't stream on this side pretty often. So the fact that we were able to hold it down, spend time together this afternoon, look at some of these legal topics, have some dialogue about it, and we're fair here. You know, sometimes, you know, you hear out the other side. If people disagree, we'll check it out. We'll check it out and see if it makes sense and listen to other opinions. We even have fun trolls. Glanville's dog was in here. You're welcome. Shout out to Glanville's dog. I'm really excited to have trolls over here on this side. But listen, guys, I'm going to run out of here and grab something to eat. I hope you have a wonderful day. I will be putting out videos throughout the week on smaller topics. Your weekly recap will be available on Sundays. I'll work with my editor on that. Other than that, we'll see you guys on Monday for the trial streams. Lead and I will be hanging around. If you have any questions, you know where to find us on social media. But I am so excited that you guys are here today. I hope you have a good weekend. Stay safe out there. See you in the next one. Bye.